And Your Honor, next I have Mr. Joshua Wilberscheid. This was originally set for entry of a plea. Speaking with the state, I believe we may be able to resolve this actually with a PTI. There's just a few more things we need to do. If I may have a continuance to get that worked out.
Yes, sir. With the representation about a possible PTI, then that's correct. So the next pretrial is March 13th.
13. Thank you very much, Your Honor. I believe that's all I have.
Thanks, Mr. Jones.
Thank you.
Mr. Garrett.
Good morning, Your Honor.
Good morning, sir.
Your Honor, Chris Garrett on behalf of Shiloh Potter, 22 CF 2292. Mr. Potter is approaching. Your Honor, we are very close to a resolution in this matter. The state has generously offered to amend the possession of controlled substance to possession of marijuana. Mr. Potter just needs to do some brief research about how that might affect his professional licensing. If we could have a short continuance, we don't need a full continuance, Your Honor, just like 2 or 3 weeks.
Well, why don't we schedule it for the next pretrial conference, and then if you want to schedule a hearing before that, enter a plea, then you can do that.
Okay, thank you, Your Honor.
So, Mr. Potter, that means that I'll see you no later than March 13th at 9 o'clock, but hopefully I'll see you before that, where you'll avoid about 300 people on that day. Thank you, sir.
Thank you, Your Honor. Have a good day.
Yes, sir. You too. Mr. Flaherty, Mr. Merriwell.
Morning, Judge.
Good morning, ladies.
Just have one on today's docket. It may be under Mr. Flaherty, Charles Lawrence, and 22 CF 391.
Yes, ma'am.
There's also an accompanying traffic citation, 22 TR 1448. We had set this matter for plea or continuance. We had continued to negotiate. We have been offered a lesser misdemeanor plea, so if we could continue this one so that I can get the logistics of the plea worked out, it should fall off the docket before the next cycle.
Okay. Yes, ma'am. Let's continue.
313, Judge?
Yes, ma'am.
Thank you, Your Honor.
Thank you, ma'am. Have a great week. Thank you. Mr. Johnson. Hey, Mr. Johnson.
Good morning, Your Honor.
Good morning,
Brian
sir.
Johnson here on behalf of Brian Dean Howard. Mr. Howard is present, although there is a waiver on file, Your Honor. This was set for clear continuance, case number 22 CF 2185.
Yes, sir. Mr. Howard, you want to come down?
And Your Honor, we took depositions last Thursday. During the course of depositions, discovered that there was, and I filed a motion on Friday, but I'm sure hadn't seen it yet. I'm sure it took a couple of days to get on the docket, but there were some reports from FDLE and what the state didn't even have yet. So we need a continuance in order to get that discovery and reset some depots.
Okay. Mr. Howard, do you agree to the continuance?
Yes.
I'll see you back here on March 13th at 9 o'clock, unless your attorney sets a hearing before that day. Thank you for gushing up. At least the top half. Thank you, sir.
Thank you, Your Honor. That concludes my business with the court. May I be excused?
Yes, sir. Thank you.
Thank you, Judge. Good to see you.
Great seeing you. Ms. Jackett? Can't see her. Mr. Darren?
Good morning, Your Honor.
Good morning, sir.
Your Honor, the first case I have on the docket is Garrett Hamilton, 21 CF 2902. He is present. Your Honor, he's going to withdraw his earlier plea of not guilty and enter a plea of no contest. I do have a written plea. May I approach?
Yes, sir. Thank you. Hello, Mr. Hamilton.
Yes, sir.
Mr. Hamilton, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, sir. You can put your hand down. Mr. Hamilton, did you read the plea agreement?
Yes, sir.
Do you understand?
Yes, sir, I did.
Did you discuss it with your attorney?
Yes, sir, I did.
Did he answer all of your questions?
Yes, sir, I did.
Are you satisfied with his representation?
Yes, sir, I am.
Did you sign the plea agreement?
Yes, sir.
Mr. Hamilton, if you'll just give me a moment. Do you understand that the 36-month suspended sentence means if you fail to successfully complete community control or probation, that you very well may be sentenced to 36 months in prison?
Yes, sir.
Mr. Hamilton, I do accept your plea. You're adjudicated guilty. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You're sentenced to 18 months community control, followed by 3 years of probation. The court does impose a 36-month suspended sentence. The court awards restitution but reserves jurisdiction to determine the amount of restitution if the state files a motion or a petition within 90 days from today. The court has no objection to your supervision being transferred to Walton County. Thank you, sir. Good luck to you.
Thank you, sir. Your Honor, the next case I have is David Nicomito, 21 CF 2993. The state made an amended offer on that case, and I received some reports on Friday as well.
And we can, hold on one second. I'm looking at the score sheet for Mr. Hamilton. It's filled in incorrectly, but I appreciate you trying to fill it in. It says 4 months probation, and it's 3 years probation. Okay, yes, sir, Mr. Bell.
Mr. Nicomito, 21 CF 2993. Judge, if we can continue his case one cycle, I received an amended offer from the state that I need to discuss with him, so if we can have one final.
Okay, so trial next time?
Yes, sir.
Okay. And I see the state nodding, so yes, sir, that's okay.
And that'll be 313, Your Honor.
Yes, sir.
Thank you, Judge. That's all I have.
Thanks, Mr. Bell.
Have a good day.
You too. Mr. Stevens. Good morning, sir.
I have 2 out of custodies. The first one is Richard Middleton in 22 CF 1409 with Mr. Gomez. We had set it for today for approval of the PTI. The state has not had that approval yet. So we're going to ask if we just leave it set for review to get that hopefully approval.
On Thursday?
Yes, sir.
Okay. Yes, sir.
And the last out of custody I have is Susan Staubitz, 22 CF 2297. She is present. I would like to just have a few minutes to talk with her first. So if we can just pass her.
You just let me know when you're ready.
Thank you.
Good.
Judge, I've been in touch with Ms. Del Bosque. She's also on the docket. Her client's number 8 on the docket is Vasquez. Ms. Del Bosque has court in Escambia County. We're close to a resolution. It's not completely ready to resolve today. So if we can just continue it so she doesn't have to drive over.
You don't want to put it on for Thursday?
No, Judge, I don't think there's any reason to do that.
So Vasquez, 22 CF 2104 is continued. Mr. Shaw. Good morning, sir.
Good morning, Judge. How are you?
Doing well. How are you?
Good. First, Judge, I think I'd like to bring up one that's on for the afternoon at 1:30. Her name's Brandy Underhill. It has been resolved. It's going to be a DPA. So we'd like to put it on for Thursday morning to get that done.
Okay.
I just didn't want you to spend time if you were going to
Yes,
look at that after court this morning to get ready the afternoon. So
Thank you.
it's resolved. First case I have, Judge, is Marcus Lee Lane, Lane, 22 CF 1994.
Mr. Lane's coming up.
Yeah. Judge, Mr. Lane's case, we would like to continue it one cycle. We left it set in hopes of getting it resolved and just haven't been able to do that. So I think it'll be ready to go next time.
Okay. Mr. Lane, I'll see you on March 13th at 9 o'clock, okay? If you want to enter a plea before that and avoid about 300 people, talk to Mr. Shaw about scheduling it before then. Thank you.
Next, Judge, is Martha Shawn Monk. Ms. Monk's approaching. Your Honor, a counteroffer was made to the state last week. I think they are still considering that. I don't know if it's something we should leave on for Thursday or continue. I don't know if you'll have time.
Do you know the counteroffer regarding this month?
I have it in my emails, Your Honor. We reviewed it. We haven't made a decision. I would, if you just want to leave it set for Thursday in terms of we can look at it then.
Okay, and then if, Ms. Monk, hold on one second. Mr. Shaw, so if there's not an agreement for Ms. Monk to enter a plea, then Ms. Monk's appearance is waived for Thursday, and then I'll see her on March 13th. But keep in touch with Mr. Shaw. Hopefully I'll see you on Thursday and we'll resolve your case then. Thank you, ma'am.
Thank you, Judge.
Yes, sir.
Judge, next I'm covering a couple of cases for Mike Flowers, who's over in Defuniak with Judge Wells currently. He has first Michael Mitchell McGahee Mulholland, 22 CF 1791. He's indicated, and I've spoken with Mr. Gomez as well, that they're still working towards a resolution and would like to continue the cycle.
Any objection?
No objection, Your Honor. I think we will have a resolution before that. I'm sure we'll be able to just put it on a day before that, 13 days.
Good. Mr. Mulholland, do you agree to the continuance?
Yes, Your Honor.
You understand what's going on with your case?
Yes, Your Honor.
Okay, I'll see you no later than March 13th at 9. Thank you, sir.
And lastly, Judge, for Mr. Flowers is Burley Lee White.
Well, Mr. White. Doing well. How are you?
And Mr. Flowers is asked to continue that one as well to the 3/13 date, Judge.
Okay. Mr. White, I'll see you on March 13th at 9, unless you want to enter a plea before that date, okay? Thank you, sir.
Thank you, Judge. That's all I have.
Thanks, Mr. Shaw. Ms. Jacob, are you ready?
Are you got this? I have a few I can call.
Okay, that'd be great. Yes, ma'am.
Your Honor, if I could pass Mr. Bryan and Mr. Papillon for now. I have William Malott in 22 CF 2469. Your Honor, in speaking with the state, we have both made multiple efforts to reach out to the Santa Rosa County prosecutor that's handling the, in my opinion, double jeopardy case. Without any response. I've even reached out to his attorney over there, and they've tried to reach out, copied myself and Mr. Gomez, and there's been no response to that. So if we could leave this on for Thursday, I think Mr. Gomez intends to call over there and speak to the supervisor to try and get some resolution to get it resolved.
Good. Okay, I'll see you on Thursday.
And Mr. Malott is in custody in Santa Rosa County, that's why he's not here.
Okay, so are you going to waive his appearance for Thursday, or?
Yes, the state's agreed to waive his appearance for both days. He wasn't set clear trial, we're just trying to get this case off the docket.
Yes, ma'am.
So.
Or at least figure out what's going on with the state not.
Yeah, or figure out if this case is going to be continuing or not. So.
Yes, ma'am.
I think the state's issue is just trying to get Santa Rosa County to agree to accept the driving charge.
Okay.
So, Your Honor, next I have Kevin Mene in 22 CF 1327. Mr. Mene is present and approaching.
Maybe?
Mr. Mene?
Mr. Mene?
And Your Honor, we do expect an amended offer from the state in this case if we could leave it on for Thursday.
Okay. Mr. Mene, I'll see you on Thursday at 9 o'clock, okay? Thank you, sir.
And then James Nesmith, who is supposed to be appearing via Zoom, Your Honor.
Mr. Nesmith, are you on?
Yes, sir.
Good.
Okay. And Your Honor, Mr. Nesmith's case is 22 CF 2693. He did contact me this morning and indicated he'd been in the hospital all weekend. I told him to go ahead and appear by Zoom because obviously there's nothing I could do at 8:30 this morning. So he is on via Zoom. We just asked to continue this case. We are still awaiting the FDLE results.
Okay. Mr. Nesmith, do you agree to the continuance?
Yes, sir.
Okay, I'll see you back here on March 13th at 9 o'clock. I hope you feel better.
Yes, thank you, sir. You too. Thank you, sir.
Thank you.
And finally, Your Honor, Eduardo Sanchez, 22 CF 2883. Mr. Sanchez.
Eduardo Sanchez.
And Your Honor, I was appointed at pretrial conference, and I believe, at least as best I can tell from the clerk's minute sheet, that Mr. Sanchez was not present for pretrial conference either. Is that correct?
He wasn't. I wasn't going to call out and said he was in the hospital.
Mr. McKinney's indicating he contacted his office stating he had a potential broken wrist. He's going to the hospital on pretrial conference. I'm assuming they told him he needed to be here today.
Why don't we, you're going to be back for inmates, correct?
Yes, I'm not going anywhere.
Okay, at the end of that, if you'll raise Mr. Sanchez's name again?
Yes.
If he's not present, then we'll address it.
Yes, sir. Thank you.
Thank you, ma'am.
Ms. Jacob? She's in there. They're in the attorney library. Mr. McLaren? I don't know who it is. Okay.
Allison, do we need to take the inmates? Do you have them up yet?
I do have them up.
So I'm deviating from my norm. Normally, I look in the gallery and say, let's get the folks out of the gallery. I still want to do that, but we have so many inmates that are being transported today from the Okaloosa County Jail. We need to get those folks back to the jail where they can bring us my next load of inmates. So, Allison? Allison, while we're waiting on that, is it okay if I take the two pro ses? Okay. Elizabeth Leesley? No. Lessini, there you go, I'll go with that. Elizabeth Lessini?
Your Honor, this was the case where she has appeared via Zoom a couple of times, and pretty much we were just waiting to get payment for her payment into the clerk. I don't know if that may have happened or if we have any.
Madam Clerk, it's 20 CF 2196.
It has not yet. She did let me know that she did submit a money order, and I did forward that email thread to your office just so that there was proof of that.
Okay, want to leave it on for Thursday?
That's good with me, Your Honor.
Okay, so it's for Thursday at 9 o'clock. Marcus Lovett. Marcus Lovett, 22 CF 1640. I don't see Mr. Lovett on Zoom or here. We'll pass Mr. Lovett's case. Okay? Allison?
I'm ready.
Good.
We have Schwab coming out.
Okay, thank you. Hello, Mr. Keith.
Schwab.
Good morning. This is Mr. Patel's case. Okay.
Good morning, Judge. Anderson. Good morning, Jay Patel and Jason McKinney on behalf of Sarah Jim Schwab. She's got several felonies on the docket. Judge, and I've not told Ms. Schwab this, I didn't get a chance, but we are tracking with the conversation we had last week between Mr. McKinney in the state and myself in the state on the different cases. Never mind. You're going to be handling his cases right now. With ours, we can bring it back on Thursday so the state can reach out to the alleged victim. So, Mr. McKinney's going to handle half the cases, and then we're going to bring Ms. Schwab back on Thursday so the state can reach out to the alleged victim, because we had a plea agreement in place, and we're looking for a small modification to it.
Okay. Ms. Schwab, I'll see you on Thursday on Mr. Patel's case. Yes, sir.
Jason McKinney on two cases, 21 CF 1543 and 21 CF 2542. We've reached an agreement in those cases in which Ms. Schwab will be entering a plea to lesser included offenses, to misdemeanors, and 1543 would be a lesser included misdemeanor battery. And that would be statute number 78403 1B, Madam Clerk.
Yes, sir. Thank you.
And in 21 CF 2542 will be a lesser included offense of a criminal mischief, first degree misdemeanor. That would be 806 13 sub 1 sub B 2. The agreement would be for court costs and time served, or with the $250 cost of defense. She would be adjudicated under misdemeanors. We did review a plea agreement at the jail yesterday. Ms. Schwab has reviewed it with me. She signed it, so have Ms. Avery and myself. And I approach with this.
Yes, sir. Thank you. Ms. Schwab, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Schwab, did you read the plea agreement?
I did.
Do you understand it?
I did.
Did you sign it?
I did.
Ms. Schwab, I do accept your plea. You're adjudicated guilty of the misdemeanors. You're sentenced to credit for time served. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You'll need to pay the $250 public defender's fee. Is Ms. Schwab, in your case, Mr. Battelle, is she going to get out of jail? Or is there going to be any time she's
No, she'll get out of jail, Judge.
Okay. Ms. Schwab, how long will it take you to pay the court cost? And okay, it's about a, yes, sir.
If I may, the deal that we're contemplating with Ms. Schwab is going to have a significant amount of restitution with a minimum payment. So I asked for the maximum time that she's allowed to pay her court costs.
Okay. Ms. Schwab, if you failed to pay the court costs and the public defender's fee within 1 year from today, then it will go to a civil lien or a judgment, okay?
Yes, sir.
Thank you, ma'am. I'll see you on Thursday.
Thank you.
Thank you.
Next I have is Coleman Marcus. Just wait a second.
Hello, Mr. Coleman.
Mr. Coleman is set for trial. We do have a plea offer from the state for 72 months in the Department of Corrections, followed by 8 years of probation. I don't know, I would like to leave Mr. Coleman set for trial on Thursday. I can tell the court that I don't expect this to be a trial. If Mr. Coleman does not want to take an offer from the state intends to file a Nelson hearing, a motion for a Nelson hearing. I'm sorry, Williams rule.
Okay, good.
Yes, I'm sorry.
Pick a last name, anyway.
Tuesday morning.
Yes, sir.
The state would intend to file a motion for Williams rule. So I don't expect this to be a trial. However, Mr. Coleman does have some last second questions, and I wasn't intending to do the witness or the inmates first. So I'd like to leave him on for Thursday. I'm going to go talk to him at the jail tomorrow.
Okay.
If the state would be okay with that.
I'll leave the offer open until jury review.
Okay. So as far as the Williams rule, would we want the hearing Thursday afternoon?
Judge, we have to subpoena our witnesses. I know that we had originally set up for docket day. This hadn't been set with subs. It was the understanding that he would plea to the bench, plea to the state's agreement with defense, or we'd be filing our Williams rule with the intention to go to trial next time. But if he has additional questions for Mr. Klein, we'll leave the offer open until jury review. At that point, it will be dismissed, or it will be revoked, sorry.
Okay. Mr. Coleman, I'll see you on Thursday, okay? Thank you, sir.
Next is John Collins. C.
Collins, yes. Mr. Collins, good morning.
Your Honor, this is John Collins. Mr. Collins was announced.
Please trial.
Oh, that's right.
If we could pass Mr. Collins, we're going to have a plea agreement here, Your Honor. It's just, I got to rewrite one of it, some terms of it, and talk to Mr. Collins real quick. It's the same thing.
So if you'll keep Mr. Collins here.
It's just,
Next is Lockhart.
Thank you. Jared Lockhart, 21 CF 2057. And case numbers after that on the docket.
Your Honor, this is Derek Lockhart. I talked with Mr. Gomez, and we are this close to resolving this with a DOC sentence. Mr. Gomez would like to review some issues with the time that Mr. Lockhart has. The proposal that we have made is 48 months, concurrent and coterminous, to resolve everything. I gave Mr. Gomez the times that Mr. Lockhart's been incarcerated this morning, so we'd like to leave this on for Thursday. It was never announced plea or trial.
My notes say that it was.
Was it? I don't recall.
Okay.
But we'd like to leave them on for Thursday morning. We should have a definite answer on how this is going to resolve.
Okay. Mr. Gomez, I'll see you on Thursday.
Awesome.
Thank you.
All right.
That's Lockhart.
I'm sorry, Mr. Lockhart, I'll see you on Thursday.
Martinez Gonzalez, next. Martinez Gonzalez.
Your Honor, this is William Martinez Gonzalez. We did file a bond motion for Mr. Martinez Gonzalez, however, we're going to withdraw that motion. Mr. Martinez Gonzalez is going to enter a plea today to resolve both of these cases. The agreed upon disposition here, Your Honor, is in 18 CF 2955, that's a BOP case. Mr. Martinez Gonzalez will admit violating supervision. In 22 CF 2219, that's a new law violation. Mr. Martinez Gonzalez will enter a no contest plea as charged in that case. In the 18 CF 2955 case, Mr. Martinez Gonzalez will be reinstated to supervision. With all of the original terms reinstated, there's going to be an additional, the court's going to modify supervision to add a special condition that Mr. Martinez Gonzalez served 90 days in the Okaloosa County Jail with credit for all time served. He'd be assessed a $100 BOP fee and $150 public defender fee. That sentence, Your Honor, would be concurrent to 22 CF 2219. Mr. Martinez Gonzalez on count 1 will be placed on 1 year of probation, concurrent to 18 CF 2955. Special condition is that he would do a substance abuse evaluation and any recommended follow-up treatment. Be assessed $615 in court costs, $150 in public defender fees. There would be a withhold of adjudication on the felony counts here. Count 2 in the 2955 case, Your Honor, is the second degree misdemeanor, no valid driver's license. Mr. Martinez Gonzalez will be sentenced to time served on count 2.
And that's an adjudication of guilt?
On the misdemeanor. Yes, sir. May I approach?
Yes, sir. Thank you, sir. Mr. Martinez Gonzalez, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Thank you, sir. You can put your hand on it. Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Martinez Gonzalez, I do accept your plea. You're adjudicated guilty of the misdemeanors. Adjudication is withheld on the felony count. In 18 CF 2955, your current supervision is reinstated with all the original terms and conditions. However, it's modified to add 90 days in the Okaloosa County Jail with credit for all time served. That's to run concurrently with 22 CF 2219. I need to pay the $100 cost of prosecution, $150 public defender's fee. And 22 CF 2219, adjudication is withheld in count 1. You're sentenced to 1 year of probation. You'll need to submit to a substance abuse evaluation within 30 days from your release from jail. If any treatment's recommended, begin that within 60 days from your release from jail. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost, and there's a $100 cost public defender's fee in that case. In the misdemeanor, you're adjudicated guilty and sentenced to credit for time served. Thank you, Mr. Martinez. Good luck to you, sir.
Matthew Palmer.
Thank you.
Palmer.
Pete.
Good morning, Your Honor. Mr. Kleins and I both represent Mr. Palmer. I believe we have dual written plea agreements that he just needs to briefly review and sign. I know that each of us discussed the terms of the plea agreement with him at the jail on Friday. We just need his signature on the paperwork.
Yes, sir.
I'll let Mr. Kleins go first.
Sure.
Your Honor, I made one change on this plea form after Mr. Palmer signed it. I had originally written that it was going to be, his sentence in my case was going to be a year of sex offender probation. It's going to be a year of regular probation.
Okay.
So the state has crossed out sex offender. That part of it is just 1 year of probation.
Okay. Could
So-
you get Mr. Palmer to initial that?
Sure.
Thanks.
And so in my case, Your Honor, 22 CF 1583, sorry about that. Mr. Palmer is going to be entering a no contest plea as charged. The agreed upon disposition in this case is that he'll be placed on 1 year of community control, followed by 1 year of regular probation. There will be a GPS monitor at $1 a day. This sentence will be concurrent to any other sentence. The only special condition here is that Mr. Palmer will complete the REAP program as a condition of supervision.
The what program?
REAP, Reentry Alliance Program.
Thank you.
I've already talked to the program and has been accepted into them.
Excellent.
So there will be court costs and 115 public defender fees, and Mr. Palmer will be adjudicated.
Thank you.
May I approach?
Yes, sir.
Mr. Kleins is with you today.
That's right. And Mr. Palmer was going to request, Your Honor, if the court would authorize him to do community service in lieu of any eligible court cost payments.
Okay. Yes, sir. Mr. Palmer, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down. Mr. Palmer, did you read the plea agreement that Mr. Kleins just stated today on the
Yes,
record?
sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
I'm looking at the score sheet.
No departure based on negotiated plea agreement, Your Honor.
Thank you, ma'am. Mr. Palmer, I do accept your plea. You're adjudicated guilty. You're sentenced to 1 year of community control. Both of these felony counts, Mr. Kleins?
Yes, sir, Your Honor. They're both 33 felonies.
1 year of community control followed by 1 year of probation. You need to wear a GPS monitor at $1 per day. The sentences will run concurrently with any other sentences, ones that will be announced today. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost, $150 public defender's fee. You'll also need to enter and successfully complete the REAP program. the community control and the probation will run concurrently in each of those two counts. Okay?
Yes, sir.
Then, Mr. Peach.
Judge, this is Mr. Palmer in 21 CF 2825. He's going to withdraw his pre-sentence plea of not guilty and tentative plea of no contest. In agreement with the Office of the State Attorney. With that, it would be a downward departure sentence that he'd be sentenced to 3 years in the Department of Corrections. That sentence would be suspended on each count. He was placed on 1 year community control followed by 1 year probation, and that would run concurrent with his case. I believe that's 22 CF 1583, the one the court just imposed with Mr. Klein's. Financial costs would be $515, $100 cost of prosecution, and $100 legal assistance fee for a total of $715. Conditions of probation would include random UAs and a substance abuse evaluation and follow-up treatment if necessary. This would also be a downward departure, which I think I stipulated to, or said on the record, we're not aware of any DNA evidence that exonerates Mr. Palmer in this case.
Okay, thank you. I've got 2 score sheets. I want to know that I'm signing the...
We did separate score sheets for each case, Judge.
Got it. 15, making sure that I'm signing the correct one. Okay. Thank you. Mr. Palmer, you're still under oath. Did you read this second plea and sentencing agreement?
Yes, sir.
Do you understand?
Yes, sir.
Did you sign?
Yes, sir.
Mr. Palmer, I do accept your plea. This is in 21 CF 2825. You're sentenced to 3 years suspended sentence, so that's hanging over your head. Just be very mindful of that.
Yes, sir.
You're sentenced to 1 year community control followed by 1 year of probation. This sentence will run concurrently with 22 CF 1583. You'll also need to submit to random urinalysis, submit to a substance abuse evaluation within 30 days from your release from jail, begin any treatment if it's recommended within 60 days from your release from jail. All monetary assessments mandated by statute or county ordinance are imposed. There's also a $150 public assistance fee. Yes,
Your
sir.
Honor, I would ask the court to consider waiving cost of supervision for the first 6 months of supervision. He's going to be in the program, but he's also been in custody for 7 months at this point. He's on disability, so.
The $40 per month cost of supervision in each of the cases is waived for the first 6 months. Then you'll only have to pay $140 per month cost of supervision for all the supervision. Probation?
Your Honor, should be asked to be hooked up with the jail before release?
Yes, ma'am.
Thank you.
Thank you, ma'am. Thank you, sir.
Thank you. And Your Honor, just for housekeeping matters, he was also on your 130 docket. We are going to withdraw or abandon our motion to compel, and he will not be needed for that hearing since he's under the plea at this time, so he can return.
Good, thank you, sir.
Thank you.
Next is McKinney. Ryan.
Your Honor, this is Mr. McKinney. I have had numerous discussions with the state on this. We have proposed a possible resolution here. The state has declined to accept that offer. All I can do at this point, Your Honor, is ask that the court set the DOP evidentiary hearing 22 CF 1223. I do intend to file a motion to ask the court to give Mr. McKinney a bond on the DOP case. I don't know if Your Honor would allow us to do that on Thursday. I don't want to crowd the docket on Thursday morning, but I believe we have arraignments in the afternoon.
Yes.
Yes. And then we have, how many sent in the afternoon?
I showed 1 to 2.
Okay, then yes, sir.
Absolutely. We'll get that motion filed today, Your Honor. So if we could set the DOP evidentiary hearing for a date in February, and then I'll have Mr. McKinney back before the court on Thursday for a bond motion.
Madam Clerk, do you have a suggestion on an afternoon?
So for the bond motion, is that going to be at 9 or in the afternoon?
In the afternoon at 2:30. Then as far as the VOP hearing in February,
The 20th has 4 set at 1:30, and then the 23rd has 3 set at 2:30.
Okay, let's do the February 23rd at 2:30.
Yes, sir.
Yes, ma'am.
So you'll be back here on Thursday. This Thursday. Okay.
Thanks, Mr. McKinney. I'll see you Thursday.
Thank you, Your Honor.
Thank you, sir.
Mr. McNabb, Jonathan?
Judge, on that VOP case, I actually show that it's set for February 16th at 2:30. Would you like to keep that?
Yes, ma'am.
Okay, so change.
Your Honor, this is Jonathan McNabb, 22 CF 791. We had left Mr. McNabb on to see if the state would consider dismissing this charge from the fact that Mr. McNabb is serving a 6-year federal sentence on the same exact fact pattern. The state's not in a position to do that. All I can do right now is ask to continue this one time, but I can tell the court I'm going to file a motion to dismiss and get that set for the first available date that is not February 16th in February.
Okay. Mr. McNabb, I'll see you no later than March 13th, but hopefully I'll see you before that date for the motion hearing. Okay. Thank you.
Murray? Bradley?
Allison Bradley?
Last name Murray.
Murray. Thank you.
This is Bradley Murray, Your Honor. He is present in 22 CF 2750. I did meet with Mr. Murray last week at the jail. Very rarely have I had a client so adamantly protest their innocence. All I can do at this point, Your Honor, is ask that this be continued. I will depose every listed witness in this case and move this as quick as I can to get this resolved.
Mr. Murray, I'll see you back here no later than March 13th, and hopefully we'll be going to trial at the end of that month. Okay? Thank you, sir.
Next is McLaren.
Your Honor, before the court is Morgan Revel in 22 CF 2521. If I may have just a moment to pause and have her sign this plea agreement. Your Honor, and I apologize, we had 2 different potential resolutions, so it's kind of a last minute decision. Your Honor, she has, she's a last minute decision, she's had both options since last week, so. Your Honor, she's going to be pleading no contest as charged. The agreement is for her to be adjudicated guilty, placed on 3 years of probation. She will have a $40 per month cost of supervision, $615 in court costs, and $150 cost of defense. She'll need to submit to a substance abuse evaluation within 30 days of her release and begin any recommended treatment within 60. She'll have random urinalysis while on probation, and she'll need to complete 25 hours of community service work. And Your Honor, in this case, Miss Rebel has a hold for a misdemeanor case, so she will not be released immediately. So I just want to make sure probation was aware of that. That's why she will not be checking it immediately. And I have a copy of the plea agreement.
Ms. Revel, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, ma'am. You can put your hand down. Thank you. Ms. Revel, did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes, Your Honor.
Did you discuss it with your attorney?
Yes, Your Honor.
Did she answer all of your questions?
Yes, Your Honor.
Are you satisfied with the representation?
Very much so, Your Honor.
Good. Did you sign the plea agreement?
Yes, Your Honor.
Ms. Revel, I do accept your plea. you're adjudicated guilty, you're sentenced to 3 years probation, and that's to run concurrently on each count, run at the same time. You need to pay the $40 per month cost of supervision, $150 public assistance fee. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You'll need to submit to random urinalysis, submit to a substance abuse evaluation within 30 days from your release from jail. If any treatment's recommended, begin that within 60 days from your release from jail. You'll need to perform 25 hours of community service work. Ms. Rebel, you were smiling when you were saying, yes, Your Honor, yes, Your Honor. I wish you the best. Substance abuse is a heck of a bear on your back. I hope that you make it through that, and I wish you the best, ma'am.
Thank you.
Probation.
You want to repeat an address for the whole, for an address, please?
Ms. Rebel, an address, you want just the city or the actual address?
The city's fine, thank you.
rule on that over lunch today. And so I'll enter that order today. Do we want to bring back Mr. Martin on Thursday?
I think that would be wise.
Judge, Dr. Zeman's unavailable next week. Could we continue this instead of on the court's next docket?
We have no objection to that.
Okay, so Mr. Martin's case is continued until March 13th at 9 o'clock. Again, I apologize. I didn't know the ball was in my court, but I will rule on that today.
All right, Judge, thank you very much. Have a good day.
Thank you, you too.
Thank you.
Make sure I get those orders, okay?
Yes, sir.
Thank you. Okay, any other private counsel on Zoom? Yeah, see? Yes, sir. Private counsel, however you want to line up. Mr.
Good
Patel?
morning, Judge. David Patel on behalf of Legal Stokes, he's president of Proceedings. Judge, this is a change of plea. Mr. Stokes is before the court in 22 CF 336. He changes his previously entered plea of not guilty and tenders a plea of no contest. The understanding is that he'll be adjudicated guilty. As charged, 3 years of probation, $615 court costs, $40 a month cost of supervision, $600 in restitution to Sean Reno and Justin Parrish. It is not joint and several. It's $300 to each of them. He's to do an anger management evaluation, enroll within 60 days, and complete the required treatment plan. And the state stipulates to a downward departure. May I approach with the score sheet?
Yes, sir. Mr. Stokes, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Mr. Stokes, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir.
Mr. Stokes, I do accept your plea. You're adjudicated guilty. You're sentenced to 3 years probation. And that's to run concurrently, run at the same time on each count. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You'll need to pay the $40 per month cost of supervision. This is a downward departure. You'll need to pay restitution of $300 to each of the victims. You'll need to submit to you'll need to enter and successfully complete the anger management class during your supervision. Have I missed anything from Mr. Stokes? Mr. Stokes, I saw that it was down for a speedy trial. I'm glad that you took it under your control and you decided what you thought was best for you. So I wish you the best in probation.
Thank you, sir.
Thank you, sir.
And Judge, I just need to cover for Robert Dees.
Thanks, Mr.
His client's name is Mr. Sanchez. I believe that Mr. Sanchez is here.
Sanchez. Oh, he's covering for Mr. Stokes.
Judge, if I can recall Mr. Sanchez, there's been an offer.
Okay, and I'm sorry, who?
For Robert Dees, Mr. Sanchez.
Okay, thanks. Mr. Sanchez, I'll see you later this morning. Thank you, sir. Next, Mr. Catalani.
Thank you, Judge. Judge, I have one case that I would like to take care of first, from Mr. Tony Henderson, if I may.
Okay, yes, sir.
And it is Mr. Michael Gilbert, I saw him present in the courtroom. 21 CF 163. Your Honor, Mr. Tony Henderson has jury selection today. What he wants to do on Mr. Michael Gilbert's case is set it for trial, Your Honor, and please set the case for a jury selection on January 23.
Okay. So, do we need to have jury review on Thursday?
Judge, I'd ask that we have jury review, see which cases are left over as far as witnesses and coordinating which cases are gonna go when.
Right.
I know he did file an objection to state's notice of intent to rely on certified records as well, so that hasn't been set, needs to be addressed. So it has to be on for review.
Okay. Mr. Gilbert, I'll see you on Thursday at 9 o'clock, okay? And then we'll look at scheduling it for trial the next week or then 2 weeks after that. Does the state withdraw any offers to Mr. Gilbert at this time?
Your Honor, state has made a downward departure offer for 10 years of sex offender probation, and that is hereby revoked at this time.
Okay. Mr. Gilbert, do you understand the state's withdrawing that offer?
Yes.
Okay, you still want to go to trial?
Yes.
I'll see you on Thursday at 9. Thank you.
We'll see you later.
Your Honor, I have one case in front of the court today. He's an inmate. It's Mr. McGregor, Marlon Anthony McGregor, case number 22CF 2810.
Can you hold on? Can you wait, let me call him for that one? They're transporting inmates back downstairs and getting more
Okay.
up, so.
Okay. Yes, sir. So, Allison, if you'll let us know when you're ready.
Yep.
Yes, sir. Yes, sir. Please. Thank you. Ms. Jacob, do you have any other folks?
I need a couple of seconds, Your Honor, I apologize.
Okay. Any other private counsel? Don't see any. Mr. McKinney, I think we did the pros. Let me go back to the pro ses one more time.
Judge, we do have Ms. Gooden on Zoom
Oh,
with
good.
the client as well.
Thank you. Excellent. Thank you. Ms. Gooden, I'm sorry I didn't see you. Thank you, ma'am.
Good morning, Your Honor.
Good morning,
My
ma'am.
client, Tyler Sparrow, is on Zoom as well.
Good.
We have this case, which we are planning on a trial. We had to reschedule the depositions. Depositions were not able to be scheduled until tomorrow. If the state still wants to go to trial, they have agreed to allow us to either do a pick and go on February 3rd. Once we do the depositions, we're going to have them transcribed. So I'll need time to have that accomplished. So we agreed to do, if the court allows, a pick and go on February 3rd.
Yes, ma'am.
Yes, Judge. So we were just planning for sometime. I know Ms. Gooden wasn't available on Monday of the second trial week, and so in order to give her enough time for the transcription, then we would do that second trial week and sometime after Monday is what the
Second trial week isn't that week. The second trial week is 2 weeks later. It's not the 5th week of the month.
No.
So February 3rd wouldn't be.
It would be the somewhere between the 7th and the 10th.
There you go. So I was going to say, I think I'm speaking at a continuing education for attorneys on the 3rd.
So then I would ask that we do a pick and go the 10th.
Do you, and Ms. Gooden, the reason why I'm hesitating is there's going to be a lot of moving parts. I'd hate to say you get to go on a pick and go and it's going to be this one day in the middle of a multi-day trial, and then that would mess that up. So do you want to have Ms. Gooden appear without her client just on Thursday?
I think that her client would need to appear to make sure that we have all the pretrial issues done of, offers revoked and
the state's going to be able to put together the puzzle of who's going to trial when on those 2 weeks.
That's the plan on Thursday.
Okay. So Ms. Gooden, I'll see you and your client on Thursday at 9 o'clock, okay?
This Thursday, Your Honor?
Yes, ma'am. That's the calendar, well, what are we calling it? Jury review. There you go. Every judge calls it something different. I adopted what the last judge called it.
And Your Honor, my client is stationed in Texas. May he appear by Zoom as he did today?
Absolutely, yes, ma'am. Mr. Scarborough, I'll see you Thursday at 9. Yes, ma'am. That's good.
And Your Honor, just to let you know, I am with Judge Wells first thing in the morning.
Okay.
And as soon as I can be there, I will be.
Yes, ma'am. Sounds good. Thank you, ma'am.
Thank you, Your Honor.
Thank you, Mr. Scarborough.
Thank you, sir.
Okay.
That's all I have. May I be excused?
Yes, ma'am. Thanks, Ms. Gooden. Mr. Catalanic,
Thank you.
we're waiting for the inmate for you, okay? The two pro ses that I called before, the one that I passed was Marcus Lovett. It's Marcus Lovett here. I don't see Mr. Lovett. Okay. Mr. McKinney, you ready?
Yes, sir.
Yes, sir, because I think they're still juggling.
Yes, sir. Veronica Jones.
Ms. Jones? Hello, Ms. Jones. Good morning.
Judge, Ms. Jones is here in 21 CF 2370. We set it over today to see if we could get to the discovery in the case. I don't have it yet. I'm going to request a continuance to the March 13th date.
You should be getting that hopefully today. I made sure that it was today got sent out. So.
Sounds like we should be getting that. If we don't, then obviously I'll reach out to the court, but we need to reschedule this for the next pretrial on March 13th.
Okay, do you want to waive Ms. Jones's presence on that date?
Not at this time, because I'd like to see if we can reach some sort of agreement prior to that time and date.
Okay. Ms. Jones, I'll see you back here on March 13th at 9, okay? Okay. Thank you, ma'am.
Christopher Ravetti. Mr. Ravetti is present in the courtroom in 22 CF 2770. We did depositions last Friday for Mr. Ravetti's case. That's going to lead to additional depositions and defense witnesses based on what we heard. We're going to request a continuance until the March 13th date so that we can schedule those.
Mr. Ravetti, do you agree to the continuance?
Yes, sir.
I'll see you on March 13th.
Thank you.
Thank you, sir.
There you go.
Yes, sir. Thank you very much.
Marquise Robinson.
Mr. Robinson? Marquise Robinson?
Recall him at the end of the docket.
Yes, sir.
Joshua Salerno.
Mr. Salerno?
Likewise, Judge may call him at the end of the docket.
Yes, sir.
Mr. Hitter Sarmiento. Look at him, interpreter.
Sarmiento Chacon.
Judge, this is Mr. Sarmiento Chacon.
Okay, before you do that, Madam Clerk, if you'll swear in the interpreter.
Do you agree to accurately translate from Spanish into English and from English to Spanish? All matters brought before the court.
I do.
Judge, we attempted depositions last Friday. The alleged victim did not appear. I'm going to ask for a continuance so that we may reset the deposition. I would note for the record that I believe she has filed a drop charge statement written in Spanish.
Mr. Chacon, I'll see you on March 13th at 9 o'clock. And hopefully we'll have some movement on your case. Thank you, sir.
Nicholas Snyder. Judge, I know Mr. Snyder's here. I've spoken with him a few times this morning. He's
Nicholas
in the
Schneider.
hallway.
Okay.
May I recall Mr.
Yes,
Snyder?
sir.
Wilmer Sherling in 22 CF 1721 is a case that we'd set over today in attempts to get the FDLE lab results. The court allowed him to not appear. If we did not receive those, I have been in communication with him. We have not received FDLE. I did waive his appearance today. So I would request a continuance until March 13th.
Yes, sir. It's continued.
Nikki Smith, followed by Philip Smith.
Nikki Smith.
Ms. Smith. Ms. Smith is approaching in 2 case numbers, 21 CF 2090 and 21 CF 3255. We were trying to get confirmation of a restitution amount in the 2090 case to assess that into the record for Ms. Smith to pay and dismiss. We're going to need to continue the other case anyhow for deposition, so I'm going to request a continuance today in both, with the understanding that we can file an assessment with Madam Clerk once we have the restitution amount from the victim in 2090.
Good. Ms. Smith, you agree to the continuance? I'll see you back here on March 13th at 9 o'clock. Okay. Thank you, ma'am.
Sure. Philip Smith. Mr. Smith is approaching in 22 CF 2365. We left Mr. Smith on the docket today to see if we could get some movement from our depositions on Friday. We are not in a position to resolve it today based on what we heard. We're going to request a continuance in 22 CF 2365.
Okay. Mr. Smith, I'll see you on March 13th at 9 o'clock. Thank you, sir.
Kyle Soto, I believe he may be on Zoom.
Good. Mr. Soto, are you on Zoom? I don't hear anybody on Zoom that says they're Mr. Soto.
Mr. Soto is, I represent Mr. Soto in 22 CF 1683, and we had left him on today's docket so that we could try to gain some ground on depositions last Friday. We did depose an officer from Fort Walton Beach, and we learned that the officers we really needed to depose based on his responses. I'm going to request a continuance from Mr. Soto. He lives in St. Augustine, which is why I was looking for him on Zoom.
Yes, sir. Okay, Mr. Soto's case is continued.
Agnes Stallworth.
Ms. Stallworth? Good morning, ma'am. Good morning.
How are you?
Good, how are you?
All right.
Good.
Judge, we've reached an agreement in Ms. Stallworth's case in 22 CF 2472. The agreement that's been reached is for Ms. Stallworth to enter a plea as charged. She would be adjudicated guilty. She would be placed on 4 years of standard probation. Special conditions would be restitution in the amount of $2,400 to Eglin Federal Credit Union, no trespass at Eglin Federal Credit Union, anti-theft course, mental health evaluation, and any recommended treatment, and standard court costs, which I believe, Madam Clerk, are $515 and a $150 cost of defense. The two matters that are not on the plea agreement that I've discussed with the state related to cost of supervision will defer to the court, but she is on a fixed income and SSD, and she has a good bit of restitution to pay. So we would request that the court waive the cost of supervision, and the state would be in agreement with an early termination of her supervision after the 2-year mark if she is fully completed, including all conditions, including the restitution.
Okay, thank you.
May I approach?
Yes. Ms. Stallworth, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, ma'am. You can put your hand down. Ms. Stallworth, did you read the plea agreement?
Yes.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes.
Did you sign the plea agreement?
Yes.
Ms. Stallworth, I do accept your plea. You're adjudicated guilty. You're sentenced to 4 years probation, and that's to run concurrently, run at the same time in the 2 different accounts. You'll need to pay the restitution of $2,400 to the Eglin Federal Credit Union. Have no trespassing at any Eglin Federal Credit Union. Enter and successfully complete the anti-theft course. Submit to a mental health evaluation within 30 days from today, and begin any treatment if it's recommended within 60 days from today. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost, $150 public defender's fee. Your supervision will automatically terminate at the 2-year mark if you've successfully completed all the terms of your supervision, including the payment of restitution. It will automatically terminate at any time after that 2 years if you do the same thing. Ms. Stallworth, how much money do you make per month?
You about 9 something.
900?
Yes.
I do waive the cost of supervision, Ms. Stahl.
Okay.
Good luck to you, ma'am. Thank you.
All right, thank you.
McGregor, we have inmates now.
Judge, may I call
Yes.
David Taylor in 22 CF 2917. The court was going to allow him to appear at 1:30. He was taken into custody in Escambia at his court date over there this morning. We're still awaiting discovery in Mr. Taylor's case, 22 CF 2917.
Yes, sir.
I'll defer to the court if we are allowed to continue this, so that I can take stock of where we're at with the Escambia County case.
Okay, and it's David Taylor.
David Taylor.
We didn't state trial on Mr. Taylor's. Any objection from the state?
No.
It's continued.
Thank you, Judge.
Yes, sir.
Second.
Go for it.
McGregor,
McGregor. Okay.
Mr. Talbot,
Good. Thanks, Mr. President.
Judge, now the motion on the plea.
Yes, sir. Thank you. Good. Hello, Mr. McGregor. Mr. McGregor, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
You can put your hand on. Mr. McGregor, so did you read the plea agreement?
Okay.
Did you read the plea agreement?
Yes, I did.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Okay, so here's what I see, Mr. McGregor, is that it would be a withhold of adjudication of a misdemeanor. Is that what you agreed to?
Yes, sir.
I do accept your plea, Mr. McGregor. Withhold of adjudication of misdemeanor. Do you have a statute number from Madam Clerk for that? Or what is the lesser included?
I believe it would be 784-031B1.
Okay, and that's for count 1. Count 2 is dismissed.
Correct.
You're sentenced to 1 year of probation. You'll need to enter and successfully complete the anger management course.
Yes, sir.
All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. And you'll have no violent contact with the victim. Who is the victim?
Your Honor, may I ask, is this us or JCS?
Oh, there you go. Do you want JCS to do the probation? Okay. So JCS will do that. And it's $50 per month cost of supervision. Thanks, probation.
Your Honor, the victim's name is, I don't want to mispronounce it, it's Esmolai.
You want to spell it for Madam Clerk?
ESMELIJ. First name. And Sylvania is SILVANIA.
She also filed an affidavit a long time ago, Judge. It's in the records.
And what is the charge that it's being pled down to?
It's from battery. Oh, yes.
It should be from aggravated battery to just simple battery.
Okay. Thank you. Thank you, sir. Good luck to you.
Thank you.
Thanks, Mr. Catalano.
Next inmate I have is Old Westy, Kara.
Your Honor, this is Ms. Kara Olszewski. Did I get it right? 22 CF 2775. We have reached an agreement with the state to resolve this. Today, Ms. Olszewski will enter a plea of no contest as charged. Count 1 is a second-degree misdemeanor. Count 4 is a first-degree misdemeanor.
The way I've written this up is count 1 would be time served. Counts 2 through 4, Ms. Olszewski will serve 6 months in the Okaloosa County Jail with credit for all time served. That would be concurrent to all the counts, $615 in court costs and $150 in public defender fees. There would be an adjudication, and she has previously been adjudicated.
May I approach?
Yes, sir.
Escort you.
So that's counts 2 through 4?
2 through 4, yes, sir. 2, 3, and 4.
Gotcha. Thank you. You'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, ma'am. You can put your hand down. Did you read the plea agreement?
Yes, Your Honor.
Do you understand it?
Yes.
Did you discuss it with your attorney?
Yes, Your Honor.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes, Your Honor.
Did you sign the plea agreement?
Yes.
I do accept your plea. You're adjudicated guilty. You're sentenced to time served on count 1, 6 months in the Okaloosa County Jail on counts 2, 3, and 4. Those are all run concurrently, run at the same time. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost, $150 public defender's fee. How long will it take you to pay? Is it about $800 maybe?
A year?
Okay. Yes, ma'am. If you fail to pay it within a year from when you are released from the county jail, then it will go to a civil judgment.
Okay.
Nothing criminal, but civil, okay?
Okay.
Thank you, ma'am. Good luck.
Thank you.
Keep smiling. Okay? Keep smiling.
Next, I have Leslie Ray, last name Ray.
Hello, Ms. Ray. Ms. Ray, who represents you? Is the public defender rep? There you go. Good.
Hey there, how are you?
There you go. Good.
Judge, we are awaiting an evaluation from Dr. McDonald in Ms. Ray's case. Unfortunately, that puts us in a position that we have to ask for a continuance. If we reach any agreement ahead of time after we receive that report from Dr. McDonald, then I'd like the ability to add this onto an earlier docket.
Absolutely. Ms. Ray, that means that I'll see you no later than March 13th. But once I get back the report, then Mr. McKinney will set it for a hearing, so I'll see you then.
Can I ask one question?
Yes, ma'am.
If my bond is paid, will I call my, the pretrial officer, Kelly, that first saw me when I got in here?
Yes, ma'am.
Okay.
Right.
Next is Villanueva. Jasmine.
Mr. McKevitt, I know that you're there. We're trying to move the inmates because we have limited capacity to hold them here at the jail, and then after that, then I'll call your case. Yes, sir. Mr. McKinney?
Oh, all right.
Judge, Ms. Villanueva is here on 3 case numbers, 22 CF 2739, 22 CF 2737, and 22 CF 1671, which is a felony violation of probation. The agreement that's been reached with the state is for a 12.1 month Department of Corrections sentence with credit for all time served. That will be concurrent in between all of the felony counts. It would be credit for time served on the 2 misdemeanor counts. Her probation would be revoked and terminated. There are court costs of $615 in each of the new cases. There's a $100 VOP fee, a total of $350 cost of defense. If I did not so announce, there would be an adjudication of guilt on all counts. Judge, I was handed a restitution form in court today that is in the amount of $950. and $97.97, payable to a Laurie Newsom, spelled Laurie, last name Newsom, Newson. That would be simple.
I'm sorry, the amount is 900 and what?
$997.97.
Is there a way we can review the cameras, because that looks like it's false. There was a bunch of pouches of wine that didn't even break.
If we agree to that, then it agrees to collection. If we don't agree to that, then it went into this case. So that's up to you.
That's fine, that's fine.
Are you sure?
Yeah, I'm fine.
Judge. And I'm announcing it in that way because I didn't know about it yesterday when I discussed it with Ms. Villanueva. When she signed the plea agreement, it's not written in the plea agreement.
Okay.
So Ms. Villanueva, in hearing that, does that change your willingness to enter the plea?
No, thanks.
Okay. Judge, may I approach with the plea agreement and score sheet?
Yes, sir. Ms. Villanueva, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, ma'am. Ms. Villanueva, so let's start with what Mr. McKinney ended with. He's added restitution of $997.97 to this plea agreement. He's done that verbally. Do you agree to that?
Yes.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Ms. Villanueva, I do accept your plea. You're adjudicated guilty. You're sentenced to 12.1 months with the Department of Corrections with credit for all time served. That's on each felony count. You're sentenced to time served on the misdemeanor counts. All monetary assessments mandated by statute or county ordinance are imposed. That's the court costs on the new case. On the new cases, the two new cases, there's a $100 VOP fee on the VOP case. Total of $350 public defender's fee. Your prior supervision is revoked and terminated. You'll need to pay the restitution in the amount of $997.97, and that will go to a civil lien.
Madam Clerk, the address is 227 Staff Drive, Northeast, Fort Walton Beach, 32548 for the restitution.
Good luck, Ms. Villanueva. Thank you.
Mr. McKinney, who's that payable to?
Laurie Newsom, Laurie, last name Newsom, Newson.
Thank you. And which case is that being assessed in?
2737.
Thank you.
You can call the docket.
Okay. Mr. Mitkevichus. Are you on? There you go. Good. Good morning, sir. And thank you for letting me know that you were not going to be here today, that you were going to come via Zoom. Who is your client?
Appreciate that. I have two cases on the docket. The first one is Jamie Misdemeanor from Inmate. Unfortunately, Your Honor, we had a misunderstanding about the nature of the plea offer from the state and met with the immigration attorney. Thought that it was we had it resolved, but the misunderstanding about the nature of the offer was going to be to get some input from an immigration counsel as to which of the options that the state is presenting to Ms. Benita Fernandez would be the least likely for her to lose her immigration status. She's married to an active duty military service member.
So you want to continue that case?
In that case, yes.
Okay, it's continued until March 13th at 9 o'clock.
Thank you very much, Your Honor. The other case I have is Leo La Chapelle Castillo. And we have yet to, I thought that we might be able to resolve this case today, Your Honor, but I haven't received the offer from this juncture, and I believe we have to facilitate further negotiations before we are able to reach an agreement in this case.
Is there an offer? Is there an offer for that defendant? If you'll pull a microphone close to you.
We had discussed, and at the time, the last of our discussions, we had made an offer, but then the victim has kind of changed course in terms of what they would be okay with. And so at this time, we're still needing to speak with the victim in terms of ironing out another offer. And so we will get that to Joe whenever we do have it, but as of right now, we don't have that.
Okay. So that case is also continued until March 13th at 9 o'clock. Thank you, sir. Thank you.
Thank you very much. We'll get your advice. Nothing further. You all have that.
Yes, sir. Thank you. Okay, then, yes, sir. You ready?
Yes, Judge. If I can recall Mr. Ortiz's case, Mr. Sanchez is here. Judge, may I approach with Ms. Davis?
Yes, sir. Okay, right. Mr. Sanchez Rodriguez, I'll see you back here on Thursday at 9 o'clock, okay?
Okay.
Thank you, sir. Thursday. Thank you. Miller Rogers, I don't think Mr. Rogers is present. Okay, that case is continued. Keontae Pride. Okay, who's the, well, we'll talk about it at the end of the day. If you want. Unless you're the prosecutor for Pride?
Yes, Your Honor. If this is a case with Mr. B, I had agreed to several continuances last week.
Okay.
I got reached out about the situation, and I had agreed to those.
Okay, so Pride is continued Wednesday.
Judge, I believe you said that there was one more. Madam Clerk stated there was one more from Dewberry.
Correct.
Same thing, Your Honor. No objection.
Okay, it's continued. Thank you.
Thank you, Judge.
Thank
May I be
you, sir.
excused?
Yes, sir. Thank you. Mr. Note?
The judge got Tower 4.
If I may approach, Your Honor?
Yes, sir. Thank you, sir.
Judge, Mr. Forrest in 21 CF 336 is going to enter a plea as charged to the understanding he'd be placed on probation for 3 years with an adjudication of guilt, $515 in court costs, 24 hours community service work, restitution in the amount of $2,347.55. I think that's to Eglin Credit Union, and a $150 court-appointed legal assistance fee. Judge, it's not part of the agreement, but my client asked me to request the court to waive the cost of supervision because of the restitution.
Okay, thank you. Mr. Forrest, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Mr. Forrest, did you read the plea agreement?
I did.
Do you understand it?
I do.
Did you sign it?
I did.
Mr. Forrest, I do accept your plea. You're adjudicated guilty. You're sentenced to 3 years probation That's to run concurrently, run at the same time on each count. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You'll need to perform 24 hours of community service work. Pay the restitution in the amount of $2,347.55. It is to the Eglin Federal Credit Union.
That's correct, Your Honor.
You need to pay the $150 public assistance fee. Mr. Forrest, how much money do you make per month?
About $900 a month.
Okay. I do waive the cost of supervision for the first 6 months, but after that, you'll need to pay the $40 per month. Thank you, Mr. Forrest. Good luck to you, sir.
Thanks, sir.
Mr. Forrest.
Ms. Corsi? Yes, sir. Thank you. Thank you, sir. Thanks. Mr. Noakes?
Judge, I then have David Nicholas Pryor. He's present in the courtroom. May I approach?
Yes, sir. Thank you, sir. Hello, Mr. Carr.
Good morning.
Good morning.
Judge, he's got two case numbers. It's 21 CF 1589 and 22 CF 2288. Based upon plea negotiations with the state, we're going to enter a no contest plea to the first case number, the 2021 CF 1589. In exchange for the entry of that plea, the state's going to no pros the newer case number, 22 CF 2288. He'll be adjudicated guilty, placed on probation for a period of 2 years. To run concurrent, he'll get credit for time served on count 3, which is a misdemeanor. He'll have to pay $615 in court costs, complete a substance abuse evaluation and any treatment recommended, and a $250 court-appointed legal assistance fee.
Okay, thank you. Mr. Cryer, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can get your hand down. Mr. Cryer, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Mr. Cryer, I do accept your plea. You're adjudicated guilty. You're sentenced to time served on count 3 of 1589. The 22 CF 2288 is dismissed. You're sentenced to 2 years probation in counts 1 and 2 to run concurrently, run at the same time. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You'll need to pay the $250 public assistance fee. Submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. You will need to pay the $40 per month cost of supervision. Thank you, sir. Good luck to you.
Thank you.
Yes, sir. Thank you. Thank you, sir. Thanks. Yes, sir. Mr. Noakes.
Judge, the next case I have is John Edward McLaughlin. Judge, he's present. The state and I have been working on these 3 cases, and we just need a little more time, so if we could get it to the next cycle.
Okay. Mr. McLaughlin, do you agree to the continuance?
Yes, sir.
I'll see you back here on March 13th at 9 o'clock. Okay. Thank you, sir.
I'll see you. Judge, and I have David Pope. Judge, we're in the same position on Mr. Pope's case. We've been exchanging emails and talking, but I think we just need to put it off until the next cycle. If we bring it in early, we will.
Okay, you have discovery or things you need to do?
No, that's not really an issue, I think.
If I may speak, I think, Your Honor, in both of those cases, both Mr. Pope's and Mr. McLaughlin, I do think that we'll get to them for a landing. It's just about ironing out some details of the offers.
Okay. Mr. Pope, do you agree to the continuance?
Yes, sir.
I'll see you back here on March 13th at 9 o'clock. If the state offers you something that you want to accept before that date, Mr. Noakes can set it for a hearing before the 13th, and you'll avoid about 300 people. Okay? Thank you, sir.
I'll let you know when I know something for sure. Judge, the last case I have you taken a break yet this morning?
Nope. Do you want it before your last case?
After. Yeah, after the break.
Okay, good. We'll take a 10-minute recess, and then we'll come back and finish up the morning. Thank you.
All rise, please.
I love it. I'm just like, pretty close. So nice. Did SJ send out your subpoenas for you guys? Subpoenas for yeah, did you send them all?
Yeah, because I made sure like right when I got back here, got sent that
Okay. Do you know the exact track?
this cycle, there's only 6. So maybe.
4 in the morning.
Yes, today. It will. All these will be added.
Robert Price, him that victim allegedly.
May not be half a day.
So we went from by Thursday, that would be so realistically,
I was like, something stressing you out. Or one that has like medical records that you need or
Because all this is currently correct, but we're facing that change. I don't know if it is Jersey.
I
like that. That's nice. And that's pretty inexpensive.
That we sent out. Was it for both weeks?
Yeah, for both weeks.
Okay. Because we're walking keeps. I had one in a depot on Friday, then we got an email from Wall today, and they both seem to act like it's just the first week.
No, is this for both
I'm
weeks?
pretty positive because we had this discussion last
Yeah,
time.
for sure. I always just do both weeks.
Right.
Yeah.
Right. So, okay.
They're just not reading.
They're cops. They're cops.
Is it gummies?
No, it's nuts and cheese and bites.
I'm sorry, I really want to devour some collars right now.
Yeah.
I could have done the morning.
I really want french fries. But I want french fries.
start 10-hour shifts, so it'll be 7:30 to 5:30. And I'll be on Monday, so I'll be on Saturday, Sunday, Monday. Everybody gets to get off, he's off Thursday,
Every Monday or every other?
I'll be off Thursday, I'll be off there Thursday. I'll be up there Monday. Yeah, no, I'm going back to work. I'll be going, I actually put in, city fire. So funny, some of the officers, I think it's Lindsay, I don't know, she said, yeah. But she's over dispatch. So she's like, well, we need to get you in here. Somebody snatching you up. For that, it's not what it is.
And it's convenient for
Close to
you?
the house, they pay for my insurance, just like sure. I mean, it pays less, but.
But you're getting back in.
Yeah, I'll get money back. Plus, I'll get money for, I'll get leave money.
I'm there for the, I'm not looking at the two things at the same time. Yeah. Oh, are you doing? I don't care, you're going to do this on it. And see what yeah. I've just been finding tons. She's in Allentown. Yeah, no, she was already. Except for me, and I was like,
2 hours, 4 hours a week. But it's not, it's doing it. But I mean, it's a oh, God. So I have, or in February, and then I think in March, towards middle March, is stone for about a year.
This year, my Christmas is in Mexico.
That'd be 4 hours a day. Well, I know Judge Ward started this year just to accommodate why
oh, and actually, I don't know why. I feel like they should definitely do it too, but that doesn't do it. Because I'm just not really ever going to leave the office, but unless it's fair, to come see what goes on. Yeah.
What, do you remember what time you said she had
My guy.
1:30?
So that's all excellent. But see, the only bad part about it is technically
This is all that's going, so he's done.
Oh, yeah, we don't.
The weirdest part is that you got
yeah.
I sat there this morning, I was like, oh, this is going to be awful. It's very freaky. I said you're doing a great job. I stuff delivered to the office this morning from the text messages from the cyber officer. For no reason.
Did you tell him that? Did you tell someone that when it was done?
Yeah, I told him.
I was like, we just learned that.
Yeah, he's just there. Go, girl.
Brady Merrifield. I need get on her terms, things. She doesn't like it. Because she was thinking, I'll talk more along with her, to ready for investigation programs office. I'll get you out of here as quick as I can. Hold on to your,
Has it been filed? No. You do, you need to file it. I need to send different spheres. We send original copies to. I'll have to look at the paper when we get back. I'll show you these. Okay. The reason I give it to Kathy is she's waiting on the court. Oh, there's not going to be a court preliminary also filed on it yet. Okay. To case initiation.
Teresa, what cases do you have?
I am here to assist Mr. McKinney with an inmate, Your Honor.
Okay.
He's not here.
Okay, do we know when he'll be transported?
We come back to you.
Okay, so later this morning? Okay. Okay.
Judge, Mr. Stevens is on Zoom to handle Mr. Reed's case, Darius Wingate.
Okay.
I was in touch with Mr. Reed last night regarding this case. Mr. Wingate is currently incarcerated in the Walton County Jail. So Mr. Reed is out of town right now. So if we can just set this for March 13th.
Okay, on Wingate?
Yes, Judge. We'll probably need to have Mr. Wingate do an order to transport for that court date, or I guess for docket day, so he can be served with some other charges.
Okay, so you want a continuance, or?
Yes, Judge.
Okay, it's continued one cycle. Mr. Stevens, any other cases that you got other than inmates?
No, sir, I neglected to cover Mr. Reed's case this morning. He asked me to cover, so he wanted to continue it. There's no objection.
Okay, thank you.
Thank you.
Mr. Noakes, do you want to do that last case that you had? Absolutely. To the PD, folks in the gallery?
I'll call real quick.
Yes, ma'am.
Make sure you're in the right courtroom. We also have another felony courtroom, court going down on with Judge Ketchel and 3B. If you don't know where you need to go, please go down to the clerk's office, sign in, and they'll tell you where you need to be. Right now.
Thank you. And I'm Judge Brown, just so you know. Okay? Mr. Klein?
I'll call them in alphabetical order, just not confused.
Okay.
First, I have Jacob Cannon. This will be followed by Brooke Davis. Your Honor, this is Mr. Cannon. We have proposed, the state has proposed a PTI agreement. We have countered with a proposal for a DPA. I do expect this is going to be resolved short of the next court date. I would ask the court to continue this one last time. I do intend to set this for trial if there's no resolution next cycle. But we're kind of in the middle of negotiations that would probably result in him not having to appear. So if we can leave him on the 313 docket for a control date, and obviously if the negotiations fall apart, I'll instruct him to be here.
Okay. Mr. Cannon, I wish you the best. I hope that one of those two works out. If it doesn't, I'll see you back here on March 13th at 9.
Thank you, Your Honor.
Thank you, sir.
Next, I have Brooke Davis. I have Francisco Trezens, Your Honor, but I have a signed misdemeanor plea for that, so I'll do that later.
Okay, sure. Hello, Ms. Davis.
This
Good.
is Ms. Davis. followed by Michelle Glowa. Your Honor, I did attempt to watch the body cameras in Ms. Davis's case last week. There were some issues that were glitching, apparently. So I'd ask the court for a one-cycle continuance. This is a simple possession case. I do expect this to be resolved next cycle. I definitely don't want to commit myself to saying clear trial, definitely, but that's my intent next cycle.
Okay. Ms. Davis, I'll see you back here no later than March 13th, okay? Thank you now.
Yeah, call them on. Michelle Glowa.
Michelle Glowa? I don't see Miss Glowa. We had talked about plea trial in Miss Glowa's case.
That's correct, Your Honor.
What does the state seek?
Your Honor.
No bond capias is issued for Miss Glowa.
Next, I have Jerry Lawson. Mr. Lawson is present, Your Honor. Similar situation with Ms. Davis, glitching body cameras. Our office recently, sometime in the past year, we don't actually have discs anymore. It's all on computer now. So I'd like to leave Mr. Lawson on for 313, but I do probably expect a resolution here, similar to Ms. Davis.
Okay. Mr. Lawson, I'll see you no later than March 13th at 9 o'clock.
Thank you, sir.
Thank you, sir.
You're good? Thank you. Next I have on the docket, Your Honor, is Johnny Lee. We had filed a waiver for Mr. Lee. I just received the discovery on Friday from Mr. Lee, so I would ask the court to continue this one cycle. I did talk to Mr. Lee, and he is aware of the request for the continuance.
Good. Let's continue.
Next I have Shanita Lloyd.
Ms. Lloyd.
Mr. Lloyd.
Good morning, sir.
Donald Lowe. Your Honor, this is Mr. Lloyd. We have announced a clear trial. We would like to leave the second jury to adopt the clear trial.
Okay. So, Mr. Lloyd, that means I'll see you on Thursday at 9 o'clock. We'll be looking at going to trial either that next week or a couple weeks after that. Does the state withdraw any offers to Mr. Lloyd?
No, this time around, we're working on trying to locate the victim, to be quite frank, and so it's one of those scenarios where by Thursday we haven't heard anything, then we'll be good.
Okay. So, Mr. Lloyd, I'll see you on Thursday at 9. Thank you, sir. Yes, ma'am. Sure.
They won't have them here until the afternoon.
Okay. Okay, so are you going to be around this afternoon?
Absolutely, Your Honor.
Sounds good. We'll see you then.
1:30?
Do we have a rain? We don't have a rain.
No.
Okay. Yes, ma'am. Thank you so much.
Next I have on the docket, Your Honor, is Maurice Longmire. We filed a waiver for Mr. Longmire. He has medical procedures every Tuesday. I did meet with him the first week of this year, and I've already, scheduling depositions is already in process.
Okay.
So I would ask the court for a one-cycle continuance. Mr.
It's continued.
Next I have in person is Donald Lowe.
Mr. Lowe. Good morning, sir.
And that'll be followed by Jalen Lucius. This is Mr. Lowe, Your Honor. I'm trying to coordinate a joint resolution here to resolve this in a case in Okaloosa County. Mr. Lowe's provided the contact information for his attorney. I'm going to call and see if we can get that scheduled. We're trying to negotiate a county jail sentence to resolve both cases. So I'd like to continue, Mr. Lowe, but this is a case that if we can get this done in February, I'd like to get it done in February. So.
Okay. Mr. Lowe, I'll see you no later than March 13th at 9 o'clock. Thank you.
This is Jalen Lucius, to be followed by Brian Majolet. I did get a chance to watch Mr. Lucius's body cameras. Based on that, I'm going to be deposing the officer who conducted the traffic stop, and I do expect there's going to be a motion to suppress after that. So I would ask the court for a one-cycle continuance for Mr. Lucius.
Mr. Lucius, do you agree to the continuance?
Yes, sir.
I'll see you back here on March 13th at 9 o'clock. Thank you, sir.
Next will be Brian Majolet, followed by Connor Maples.
Hello, Mr. Majolet.
This is Mr. Majolet, Your Honor. We did receive the PTI agreement last week. I would like to talk to Mr. Gomez. There's some terms in here that Mr. Majolet is concerned about. So I'd like to leave him on for a control date for 3/13. I do expect it's probably going to be resolved outside of court, though.
Good. Mr. Maggiore, hopefully I won't see you on March 13th at 9, but if it doesn't work out before that date, I'll see you then. Thank you.
Next, I have Connor Maples.
Connor Maples?
Mr. Maples is actually in the courtroom right now.
Good. Mr. Maples, come on up. Good morning, sir.
This is Mr. Maples, Your Honor. We do have a PTI agreement signed for Mr. Maples. I have already instructed him he's going to have to take the original to the probation office today, directly from court.
Okay.
So I don't know how the court, I only have one copy, so.
We usually just set it for a control date.
I was going to say, I think we just set it for control dates and then probation will e-file it.
So, Mr. Maples, I'm just going to set it for March 13th at 9 o'clock. But if you're in PTI, then it'll drop off the docket. Okay? Thank you, sir.
Yeah, any questions? Next on the docket, Your Honor, is I have Andrew Madiak, followed by Seth McDonald. Mr. Madiak wasn't present earlier. I talked to Mr. Gomez. I believe the state has.
Is he behind you?
This is Mr. McDonald.
Okay.
Your Honor, at this time, based off of our discussions with the victims in the case, they have requested that we dismiss these charges and decline to prosecute. So at this time, the state's going to be dismissing it.
Okay, so 22 CF 2614, Mr. Madiak's case is dismissed.
This is Seth McDonald, Your Honor. We have proposed a plea to a lesser included offense here. Mr. Gomez needs time to review that. I do expect there's probably going to be a resolution in February for Mr. McDonald's case, but we would like a one-cycle continuance.
Okay. Mr. McDonald, do you agree to the continuance?
Oh, yes, sir.
I'll see you back here no later than March 13th at 9, but if you want to avoid about 300 people, you can set it for next month. Okay.
Yes, sir.
Thank you, sir.
I'll let you know. Thank you. Next I have on the docket is Mara Mearns. We did file a waiver for Ms. Mearns. I talked to her last week. I am going to be deposing the officers in this case in anticipation of filing a motion, so I would ask the court for a one-cycle continuance.
Yes, sir. It's continued.
Next I have on the docket is Kelly Midget, followed by Brian Moore. This is Ms. Midget, Your Honor. This is the last of my PTI agreements. Ms. Midget, I know she was in court last week in stating that the merchandise in question was returned. I need to find proof of that. It's a significant amount of, it's $2,400 here, almost $2,500. So I would ask the court for a one-cycle continuance. I've already talked to my investigator about trying to get proof of this.
Right.
And so if we can get the restitution issue resolved, I would expect us to not have to appear on 3/13, so we can leave it for control, just in case.
I'll see you back on March 13th at 9 o'clock. That's not resolved before that.
Thank you.
Thank you, Ms. Mitchell.
Brian Moore. Your Honor, Mr. Moore was in court last week.
I'm sorry, what's his name?
Brian Moore, 22 CF 2629. There's a Michael Moore on Zoom. Different individual.
Can you repeat the case number?
22 CF 2629.
Because I don't have it on my document.
I only have Shannon Moore on my docket.
Right.
Okay, that's perfect. Then we'll even set on the 3/13 docket.
Okay. Thank you.
But I do have Shannon Moore. She is present.
Shannon Moore, Ms. Moore.
And that'll be followed by Gavin Olson. Your Honor, with Ms. Moore, we had left her on trying to get this resolved. The situation with Ms. Moore is, I have two different offer sheets that both reference both cases, but one's a guidelines offer and one's a probation and a withhold offer. So I'll talk with Mr. Gomez and see if we can get the clarification on which is which. Certainly, we always encourage the state to err on the side of caution. But we'll ask for a one-cycle continuance. If we do get an early resolution, we'll get it.
Mr. Gomez, you can't clear that up now? You have the same ambiguity?
The score sheet that I have on the most recent case, which would have included both of them, has their scoring, has a score of 14.4, which is what I think the guidelines offer was made. So I'll have to get with Scott and go through the discrepancies that we have.
Okay.
And just to be clear, Your Honor, the first offer sheet that I have was made before Mr. Gomez was assigned his docket, so.
Understand. Ms. Moore, do you agree to the continuance?
Yes, I'm okay with that.
Okay, I'll see you back here on March 13th at 9. Thank you, ma'am.
Next I have Gavin Olson, followed by Christian Perry. This is Mr. Olson. Your Honor, the state has advised me that they're not in a position to consider dismissing this case just yet. I would like to talk to Mr. Gomez some more about that. This is a driving and a failure to provide insurance claim. So I'd ask to continue this to 3/13, but if we can get this resolved, we'll certainly do that before that date.
Good. Mr. Olson, I'll see you no later than March 13th at 9. Thank you, sir.
Yes, sir. Thank you, Judge.
Thank you.
Have a good day. Next I have Christian Perry, followed by Carl Perkett. This is Mr. Perry. We did take the deposition of the alleged victim, one of the alleged victims, the first week of this month. The second individual did not show up. I know Mr. Gomez has indicated he wants to try to talk to that individual. I'm trying to get this done as quick as I can. Mr. Perry made it clear last week that he wants this a plea as quick as possible. The problem is as charged right now, it's a guidelines offer. So we do need some participation with the state. As soon as we can get that resolved, though, I'll get Mr. Perry. Ideally, I'll have him back here on Thursday.
Okay.
I don't want to put him on the docket, but if we do get a resolution, expect Mr. Perry to be.
I understand. Mr. Perry, I'll see you no later than March 13th at 9, but hopefully I'll see you before that date. Okay? Thank you, sir.
Next, I have Carl Perkett, and we followed by Larry Pursley. This is Mr. Perkett, Your Honor. He has set an administrative review hearing to ask the DMV to review the denial of his hardship application. That's set in the month of February. I would like to ask for a one-cycle continuance because I'm trying to see if the state would be okay if showing proof that he's at least doing everything he possibly can.
Gotcha. Understand. Mr. Perkett, I'll see you back here no later than March 13th at 9. Thank you, sir.
Let me know as soon as you know. The last one I have in the gallery, Your Honor, is Larry Pursley. Similar situation with Ms. Davis, my body cam issues from last week. I would ask support for a one-cycle continuance. If we do get an early resolution here, we'll advance it on the docket.
Mr. Pursley, do you agree to the continuance? Yes, sir. I'll see you back here on March 13th at 9 o'clock, okay? Thank you, sir.
I think that's all I have in the gallery.
Okay.
Long take half a second, Judge.
Mr. Noakes?
On Larry Pursley, could we clarify whether or not the 2 counts were null pros in court on December 15th? Because I showed that they were worked up as null pros.
Hold on 1 second. That's certainly intriguing that we just talked about that case as if it's going forward, but Madam Clerk, can you respond?
It's hard for me to tell. So I see a not guilty plea on the minute sheet, and it was worked up as if they were dismissed. So I just want to make sure that when I delete
when
it out.
supposedly was it not?
December 15th.
Wow.
Because on December 15th, I have my notes say that it was set for 1/9/23 and that the PD was appointed.
Okay. And that's what the minute sheet shows. I just show other things after that. So I just want to.
Okay.
I'll clear all
So
that
it's
out.
not null pros. Okay, thank you. Mr. Noakes? Please. Thank you, sir.
Judge, I've got Kelsey Volkers, 22 CF 1527. Judge, she was initially charged with a felony, and based upon plea negotiations, we're entering pleas to 2 misdemeanors that are simple batteries. The understanding with the state is that she'd be adjudicated guilty and be placed on 1-year probation on count 1, 1-year consecutive probation on count 2. Special conditions are outlined in the plea agreement. There's also an understanding with the state that the second year of probation is allowed to be switched to administrative probation, provided all the conditions have been met and there's been no violations.
What is count two?
A simple battery also. I don't know, the state's probably gonna have to file a separate information.
Yes, sir. They're gonna have to file an amended before we can take a sentence.
We'll file amended information and date it to today, to 2 misdemeanor counts.
Ms. Volkers, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do, Your Honor.
Thank you, ma'am. You can put your hand down. Ms. Volkers, let me make sure that I understand. Okay. Ms. Volkers, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, I do.
Did you sign it?
Yes, sir.
Ms. Volkers, I do accept your plea. You're adjudicated guilty. You're sentenced to 1 year probation on count 1, 1 year probation on count 2, to run consecutively for a total of 2 years. However, if you successfully complete all the terms of your supervision during the first year, then the second year will be administrative probation. You'll need to pay the $270 in court costs, submit to a substance abuse evaluation within 30 days from today, begin any treatment if it's recommended within 60 days from today. Court does award restitution, but reserves jurisdiction to determine the amount of the restitution. You can't use or possess any alcohol during your supervision, so you'll need to submit to random UAs and also random breath tests. You'll have no contact with the victims. Who are the victims?
In this case, Judge, we have WMD, date of birth 11/16/2004, and ILA, date of birth March 2nd, 2007.
So, Ms. Volkers, you can't have any direct or any indirect communication with those victims. Can't ask anybody to tell them anything from you. You can't post anything directed at them online, okay?
Yes, sir.
You'll also need to pay the $40 per month cost of supervision. Thank you, ma'am. Probation?
As these are misdemeanors, Your Honor, are they with the state or JCS?
Doesn't necessarily matter. She just lives in Crestview, so we need to make sure whoever's supervising, she can contact them in Crestview.
Well, it's up to you, Mr. Noakes. What would you like?
Well, I'm fine with JCS.
Okay, then JCS, and it's $50 a month supervision. Thank you, ma'am.
Thank you for your time.
Thank you.
Ma'am.
Judge, that should be all I've got.
Thanks, Mr. Noakes. Yes, sir. Okay. And don't forget the folks on Zoom, okay?
Yes, sir. May I call Philip Wilson?
Certainly.
Out of the audience? Mr. Wilson is here in 22 CF 166. It is on Your Honor's trial docket. However, we've reached an agreement.
Yes, sir.
Mr. Wilson, at this point, would be waiving the right to plead not guilty and enter a plea of no contest as charged. The agreement is for 3 years of probation in count 1, which is the felony for PUI. In counts 2 and 3 will be time served. Each of those are misdemeanors. There is a standard court cost, $150 cost of defense, an adjudication of guilt on all counts, a $2,000 DUI cost or fine, a $90-day vehicle impound. I wish it was only $90. And then, as pursuant to entry of this plea, there is a permanent driver's license revocation. I've explained to Mr. Wilson a little bit about the business purposes only hardship license. So we would ask the court for the ability for counsel to provide Your Honor an order that waives the waiting period as he files an application for a hardship license.
Yes, sir. I do waive that. In relation to cost of supervision, Mr. Wilson is on fixed income. We would ask the court to consider waiving the cost of supervision.
May I approach with the plea agreement?
Yes, sir, thank you. Mr. Wilson, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Mr. Wilson, did you read the plea agreement?
I did.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
I did.
Mr. Wilson, I do accept your plea. You're adjudicated guilty. You're sentenced to credit for time served on counts 2 and 3. Sentenced to 3 years probation on count 1. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost. You'll need to pay the $150 public defender's fee, pay the $2,000 fine. Vehicle is impounded for 90 days. Your driver's license is permanently revoked. Mr. Wilson, how much money do you make per month?
$1,500.
I'm sorry?
$1,500.
Okay. Mr. Wilson, I do waive the cost of supervision.
Thank you, sir.
Thank you, sir. Good luck to you.
Can you please restate what was waived?
What was waived? The cost of supervision?
Something about an application?
Oh, the time period, the delay for applying for a hardship driver's license.
Madam Clerk, I'll follow that with a supplemental order for the court related to the hardship license DMV. Yes, sir. Judge, if we call Miranda Rice. Ms. Rice is present and approaching in 22 CF 2125.
Yes, sir.
Ms. Rice will be entering a plea of no contest as charged. Adjudication is going to be withheld when she's going to be placed on 24 months of probation. Special conditions would be a substance abuse evaluation within 30 days and a treatment within 60, random urinalysis, anti-theft course, no trespass at Wildwood Garden Shop and Nursery, reserve over the amount of restitution for 60 days, there would be a $40 a month cost of supervision. May I vote?
Yes, sir. If you'll please raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thanks, Ms. Rice. Ms. Rice, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Ms. Rice, I do accept your plea. Adjudication is withheld. You're sentenced to 24 months probation. You'll need to submit to a substance abuse evaluation within 30 days from today. Begin any treatment if it's recommended within 60 days from today. Submit to random urinalysis. Enter and successfully complete the anti-theft course. Have no trespassing at the address Mr. McKinney stated today on the record. The court does award restitution, but reserves jurisdiction to determine the amount of the restitution if the state files a motion or a petition within 60 days from today. You'll need to pay the $150 public defender's fee, $40 per month cost of supervision, and also the court cost. Thank you, ma'am. Good luck.
Madam Clerk, the address is for the Wildwood Garden Shop and Nursery is 10th Avenue, Shalimar, Florida, 32579. Davon Smedley.
Mr. Smedley?
Thank you.
Mr. Smedley is here in 22 CF 2688. We did depositions last Friday. I have conveyed an updated offer to Mr. Smedley. He's indicated he wishes a little bit more time to talk to me about that offer. So I'm going to request a continuance until the March 13th date and ask the state to leave the offer open until that time.
Okay. Mr. Smedley, I'll see you back here on March 13th at 9 o'clock. Stay in touch with Mr. McKinney, okay? Thank you, sir.
There's a Joel Walls on the docket in 21 CF 1796.
Okay, hold on one second. Mr. Smedley? Is that your father to your right? Your name's Mr. Smedley also, I take it? Mr. Smedley, thanks for coming for your son. So many folks come alone, and I really appreciate, the court really appreciates you being here with your son and supporting you. Thank you, sir.
Judge, there's a Joel Walls on the docket, W-A-L-L-S, 21 CF 1796. The court waived his appearance today and is already set for pretrial on the March 13th date. We left on today to make sure that I got the additional discovery that I was seeking. I've received that from the state.
Good.
The next step for Mr. Walls will be scheduling a motion to suppress after I have a chance to actually get to the office and review the additional discovery that has been provided.
Okay, so Walls is continued one side.
Correct. There should be a DeCarlos Weathersby on Zoom.
How you doing, sir?
Hello, Mr. Weathersby.
How you doing, Mr. Judge Brown?
Doing well. How are you?
I'm doing great.
Good. Mr. Weathersby, if you will, if you'll take off your beanie or your hat.
Oh, yes, sir. No
Thank you,
problem.
sir. Thanks. Mr. McKinney?
Mr. Weathersby, there is an updated offer from the state. Currently, you're charged with third-degree felony possession of controlled substance. The amended offer from the state would be to reduce that to a misdemeanor possession of paraphernalia charge for a court cost of, I believe, Madam Clerk, is it $270 or is it $320? $270 and a $150 cost of defense. There would be no probation as part of that agreement, so we would only be time served and costs to a misdemeanor. In hearing that offer, is that something that you are comfortable accepting over Zoom?
I mean, Mr. McKinney, honestly, you know me, I'd be the one to ask you first if that was smart to do, but I don't think I can necessarily do that, like, you know, this far away, so I'll take that plea. Yes, sir, that's good. I'll take it.
Yes, sir.
So Mr. Weathersby would be adjudicated guilty of the misdemeanor.
You'd be adjudicated guilty of a misdemeanor paraphernalia, and Mr. Weathersby, I've got no problem telling you on the record that that's a good idea.
Yes, sir. Okay, yes, sir, I'll definitely do that. Yes, sir.
Mr. Weathersby, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you. You can put your hand down. So, Mr. Weathersby, if I accept your plea, do you understand that you're waiving your right to a trial by jury?
Yes, sir, I do.
And you understand what you would be sentenced to? You'd have to pay the court cost and the $150 public defender's fee, and you'd be sentenced to credit for time served.
All right, yes, sir. I'm just going to ask Mr. Judge Brown if you find if I have a little bit of time to pay that, sir.
Yes, sir. How long do you think you'd need to pay that $400?
I'd say about 6 months, just because I get paid every 2 weeks and I just landed my job here, so yes, sir.
Okay. Mr. Weathersby, I do accept your plea. You're adjudicated guilty of the misdemeanor. You're sentenced to credit for time served. You'll need to pay the $270 in court costs, $150 public defender's fee. If you fail to pay that within 6 months from today, then it will go to a civil lien or judgment. Okay?
Yes, sir. Thank you so much, Mr. Judge Brown. Thank you, Mr. Jason McKinney.
Yes, sir. You would pay that through the Okaloosa County Clerk of the Court, so you would want to call them and get on a payment plan.
Yes, sir. No problem.
Thank you, sir. Good luck to you.
Thank you. Yes, sir. Thank you.
Nicholas Snyder is in the courtroom. Yes, Mr. Snyder is approaching in 22 CF 1860. We have been negotiating back and forth with the state for Mr. Snyder. And Mr. Snyder has asked me for additional time to get more information related to his family members in New Orleans that he's supporting. Part of the offer here relates to community control. That's Mr. Snyder's concern. The offer that we've been going back and forth with today is 1 year community control followed by 2 years probation with restitution, community service hours, no contact provisions, anti-theft, and no trespass. So I wanted to make record of that so the court was aware of where we're at with this case. So in asking for additional time for Mr. Snyder to think about that offer, we'd ask the state if they would leave that offer open for a period of time.
To the state?
Judge, I'll leave it open until our first date in February.
Okay.
I think that's the 16th.
Yes, ma'am. Okay, so the underlying case will be continued until March 13th, but I'm setting a
Control date,
I'm trying to figure out it.
status hearing,
It's usually not a,
Early plea, Judge.
there you go, okay.
Change of
Early
plea.
plea, change of plea for February 16th at 9 o'clock. So what that means, Mr. Schneider, is I'll see you February 16th at 9 o'clock. If you don't accept the state's offer, then we'll talk about them withdrawing it, and then we'll be looking at going to trial in March. Okay?
Yes, sir.
Thank you, sir.
We can come back here on the 16th of February. Yeah, give me whatever letters you want. Summer White.
Summer White? Ms. White? Nope.
Yeah, we left Ms. White on, and the court was going to waive her appearance because we were waiting on FDLE to determine whether or not we were going to be in a position to move forward or not. We don't have the FDLE for Ms. White, so we'd ask to continue it until the March 13th date.
And I did waive her appearance?
Correct.
Okay.
The court told her she didn't have to come if we didn't have FDLE.
Good, it's continued one cycle.
Marquise Robinson. Yes, another person that is in that same boat.
Okay, instead of doing those, do we have other folks in the gallery that we want to?
Mr. Salerno? I believe Mr. Salerno is here.
Hello, Mr. Salerno, I saw you sneak in there at the end.
Mr. Salerno is here in 22 CF 772.
Mr. Salerno, how do you spell your name?
Salerno.
Thank you, sir. Thank you.
It's on the docket as Salerno's, but it
Got it.
indicates as Salerno. Judge.
Yes, sir.
This was not announced on the Your Honor's trial docket. There was a probation offer that's been made to Mr. Salerno that would dismiss count 3 in exchange for a plea to counts 1 and 2. I've explained that to Mr. Salerno at the lectern. He's indicated he doesn't wish to accept that at this point. I would be forced to ask for a continuance since this is not on the trial docket. But in hearing where we are procedurally, that would mean that we would be ready for trial when we come back in March.
Understand. Mr. Salerno, I'll see you on March 13th at 9 o'clock, and we'll be looking at going to trial at the end of March. Thank you, sir. Okay, the folks that are in the gallery, if you're a defendant, are you waiting on inmates?
I'm waiting on my son, the inmate.
Okay, what is his name? Okay. Do we have them present? Can you present?
Wallace is not here.
Okay. You're having problems with transporting because they can only transport a certain number of people?
I can get everyone that we have now and have to go down.
Okay.
It's difficult for me to say what.
Yes, ma'am, but if folks are waiting in the gallery for somebody that's not going to be here until this afternoon, you'll let them know.
Rubens? Okay, Rubens is here.
Judge, also, Elizabeth Lassini, that we had taken care of earlier, she's now on Zoom.
Good.
I didn't know if we could have any.
Absolutely. Okay, for Mr. Walls, his son won't be here until this afternoon. Is that accurate?
I'm about to go on.
Okay. Ms. Lassini?
Yes, sir.
Okay. Mr. Gomez, what did we do on Ms. Lassini's case?
So, the last time we were here, there was, it was pretty much just getting, the cost paid from the DPA. At the time, there was, unable to accept payment through the clerk. She needed to have sent a money order. So I think what we did here is we were, moving it to Thursday just to get confirmation that we have received the money order. And then once that happens, she'll just get taken off the docket.
Okay, so is there any way, Ms. Lucini, will she hear from the clerk if it's taken off? Or how will she know? Go ahead, Ms. Lucini. Yes, ma'am.
Apologize. I have not heard anything yet. There was a slight snafu this week in regards to the method of payment that would have worked. I wasn't able to pay over the phone or via the online portal, so I did send a money order. I have forwarded to a court liaison as well as the clerk of court and your JA copies of my receipts for the money order that I sent, as well as the U.S. postage tracking.
Okay. Ms. Lucini, I was just asking Madam Clerk if she thought that it would come through, and she cringed. So do we want to set it? I mean, we can set it for a date farther out. I mean, I trust Ms. Lucini that she's gone through those steps. And once we receive payment, it'll just fall off the docket, and then our office can reach out, or the clerk can notify both. Ms. Lucini, let me just continue your whole case until March 13th at 9 o'clock. But if that payment goes through, then the state then will dismiss the case, and then you don't have to be here then, okay?
Sure. It should be there today. I did next day air it, but with the holiday weekend and all, they said that it would be there today.
Yes, ma'am.
According to tracking it for me.
Sounds great. Thank you so much, ma'am.
Thank you.
Your Honor, I have a couple individuals on Zoom.
Okay. Yes.
I have Jeremy Lorman.
Lorman, L-O-R-M-A-N-D.
Good morning, Mr. Lorman.
Your Honor, this is Mr. Lorman. I would like to ask the court for a one-cycle continuance. We did depose the alleged victim in this case. There's an issue about whether or not money is still owed to this individual. I have not heard anything back on whether that's the case. So I would ask the court for a one-cycle continuance so we can get an answer on that.
Okay. Mr. Lorman, I'll see you back here on March 13th at 9 o'clock.
Thank you.
Thank you, sir.
Your Honor, Darby's iPhone would be Darby Boudreau.
Yes, sir. 19 CF 3062. Yes, sir.
Ms. Boudreau, can you hear me?
Yes, I can hear you.
Hey, Darby, I talked to the state, and I believe what we're going to do is put you back on the PTI program so you can make these payments. I'm going to have to ask for a continuance here, but I don't expect that this is going to be an issue. We'll probably get this resolved outside of court. So that way that'll give you some more time. You don't have to every other month come in here and take up a docket space. So, Your Honor, I would ask for a one-cycle continuance. I do expect to have this done by the end of this month, though.
Ms. Boudreau, if it's not resolved in PTI before March 13th, then I'll see you then, okay?
Yes, sir.
Thank you, ma'am.
And the last individual...
You too.
The last individual on Zoom, Your Honor, that I have is Michael Moore. He is not on today's docket. He was on last Monday's docket, the 7th. Mr. Moore failed to appear in 22 CF 1080 is the case number. The court has issued a capias. Mr. Moore is going to request that the court withdraw the capias based on his appearance on Zoom today.
Okay. To the state, any objection to that?
We would not have an objection.
Okay, so what about Mr. Moore's underlying case?
So, deposition space has been a premium. And unfortunately, after he failed to appear, we had to file a notice of canceling the depositions. I'll talk to my assistant as soon as I get back to the office and see if we can get that time back. I think there's just one remaining deposition that we need to take. We've already taken at least one.
Okay. Mr. Moore, I am withdrawing the capias, but the problem with you not showing up makes the court cringe because the depositions that were previously scheduled were canceled. I don't like that at all, because one of the things that the court has to do is take control of the docket and move the cases forward. If you fail to appear in the future, it very well may be a no bond capias and I may not withdraw it. So you need to make sure that you're present when you need to be. Your microphone's muted, just so you know. So I'd like to see you. Where do you live, Mr. Moore?
I'm in Mobile.
Okay. So your case will be called. Your case is set. Hold on, Mr. Moore. Your case is set for March 13th at 9 o'clock. You can attend that via Zoom, but if we go to a docket day, you'll have to be here live. So March 13th, 9 o'clock. Stay in touch with Mr. Kleins, okay?
I will. I appreciate it, Judge. Thank you.
Thank you.
You have a good day.
You too. Okay, so I think that's everyone on Zoom. Yes, sir.
Alrighty, so I have Rubens,
Okay.
Judge, this is Mr. Lyle Rubens before the court in 22 CF 2311.
Yes, sir.
Mr. Rubens is before the court today after the court has granted a motion for an evaluation for competence. Dr. McDonald has evaluated Mr. Rubens and provided an order to the court, or an evaluation to the court and counsel. I've reviewed that. I believe the state is in a position.
I haven't seen that.
I do have an extra copy.
Please, could you just show it to me?
I have written down mine, Judge, but I certainly have a copy.
Thank you.
May I approach with this copy?
Yes, sir. Mr. Rubens, is that, who's in the gallery behind you? Your mom? Good, I'm glad that she's here. Thank you. So if you'll just give me a moment. Okay. Yes, sir. I do find Mr. Well, does the state have any objection?
No objection, Your Honor. We stipulate the finding of competency in the report by Dr. McDonald.
I do find Mr. Rubens incompetent to proceed. Are you seeking for him to be placed in with the Department of Children and Families?
Yes, Your Honor, we are.
Yes, Your Honor. It was the opinion of Dr. McDonald that he be remanded to care and custody of the Department of Children and Families and Florida State Hospital.
Okay. Mr. Rubens, they'll take you to the Florida State Hospital, and it estimates that you should be able to be back before the court within about 6 months. Mr. McKinney, I've watched the mother. She's very distraught at this. I have a feeling that she feels like that, I mean, just from reading between the lines, that she thinks that her son maybe will not be restored. If you find that that's not going to happen, if you can bring Mr. Rubens' case back before that 6-month mark, then the court would certainly like to see it. We don't want him to just be sitting there for no good reason. Okay.
Yes, Your Honor, and I'll provide an order to the court so that he's transported there as quickly as possible, because that would determine the timeline of how quickly he would be able to get back.
Yes,
or to provide us with an additional update or evaluation which relates to his status.
Okay, so do we want to set it for a status 6 months out?
Normally I would provide the order
that
he be committed to the care and custody of Department of Children and Families, Florida State Hospital, and
Yes,
then
sir.
they would inform the court upon when he's ready to be returned.
Okay, yes, sir. Okay. Thank you, Mr. Rubens.
Claiborne?
Well, Mr. Claiborne.
How you doing, sir?
Good. Mr. Claiborne, who represents you? Who's your attorney?
I haven't found one, sir.
Okay. Got it. Yes, sir.
I'm showing you as Mr. Kleins.
I know. I saw that too. Mr. Kleins?
Yes, sir.
I saw on the docket where the public defender was appointed, well, he qualified with the clerk.
The issue with Mr. Claiborne, Your Honor, is that we conflicted off Mr. Claiborne's case. The Regional Conflict Counsel was then appointed. Ms. Jakewood filed a motion to withdraw based on the amount of bond that Mr. Claiborne posted, and the court granted that motion. So that's Mr. Claiborne's position right now.
I understand. And then there was something that was on the docket when I was doing my homework that showed the PD being appointed again, didn't it? And the clerk was the one that determined that he qualified, I think. Okay. So we're in an infinite loop.
Given the seriousness of the charge, Your Honor,
I agree.
I would make an oral motion to withdraw based on conflict and have RCC be appointed to Mr. Claiborne's case. I've been keeping an eye on it. Every time he's been in here, I'm like, that's not
Right.
going to happen.
Okay. I do grant the public defender's motion to withdraw. Ms. Jakewood, if you don't mind, and thank you for being here.
Yes.
You want to come up? I understand, I can see your motion in my head as far as that he decided to have whoever put the money up for him to get out of jail versus hiring an attorney. But at what point, after he's been incarcerated, at what point does that lose its force?
Well, I think the other side of that, Your Honor, is if the court's position is if somebody pays a bond and they pay that amount of money to the bondsman, then they're no longer considered indigent for the purposes of having court-appointed counsel. If they just don't work for a couple months and then reapply, do they get to be indigent again? I'm not really sure at what point. Again, as a court, I'll call it the same thing, an infinite loop where we basically allow people to just, okay, well, I'll get the benefit of a free attorney if I don't work, so I'll stop working.
Okay, but Mr. Claiborne is incarcerated.
Correct, Your Honor, but I think it's the same kind of, that's the equivalent of it, is he's not working now, is what the court's saying, he's incarcerated, so he's not working. That doesn't change the fact that he paid the $18,000 for bonds next one.
I understand. Is there any bond that applies to Mr. Claiborne at this point?
I have no idea, Your Honor.
Madam Clerk?
I apologize.
Is there any bond? Is it a no bond for Mr. Claiborne at this point, and that's why he's in jail?
He does have a bond, yes.
What is the amount of that?
My bond's revoked, Mr.
That's what I was thinking.
Judge Brown. It was due to the misdemeanor charge, and the misdemeanor charge got dropped. So all I'm in here is on is this case right here.
Okay, thank you. And then we go back to if the court appoints regional conflict counsel, and then regional conflict counsel files a motion to set bond because the misdemeanor was dismissed, then are we back in that scenario again? It's difficult for the court, but as Mr. Klein stated, and as I know with the charges against Mr. Claiborne, and I had stated trial this cycle, a pro se representing himself on those charges, it's going to be an interesting trial.
Yes, they were revoked October 3rd of last year.
October 3rd, okay. Mr. Claiborne, based upon everything that I know, I do appoint the clerk said that you qualified for the public defender. I find that you qualify to be represented, and I do appoint the regional conflict counsel, since the public defender has a conflict, and that is in light of what's happened in the past, including that you've been incarcerated since October of last year.
Yes, sir.
Ms. Jacob.
And Your Honor, at this point, I'll ask to continue the case. I don't know at this point what's going on in the last several months, whether there's going to be a conflict in my office. I'll have to evaluate that.
Yes, ma'am. Mr. Claiborne, I'll see you back here no later than March 13th, but if Ms. Jacob wants to set a hearing before that, or if she does a motion to withdraw for a conflict or whatever, so I may see you before then. Okay?
Yes, sir. I wouldn't, because I know she probably don't want to represent me, so I don't think that it'll be my good interest for her to represent me due to, you know what I'm saying, the friction between the case. You know what I'm saying?
I
can see that she
understand.
don't want to represent me, so I don't think that would be my best interest to let her represent me.
I understand the philosophical conflict, or at least concerns that Ms. Jacob has. It's apparent by her stature. That's not her normal way that she acts. She doesn't agree with what I just ruled, but she's a professional. I have no reservations that she will represent you the same way that she would anybody. So I think that she will. I know that she doesn't like my ruling. I know she's protective of her office, but I believe that she'll act professionally in the future. But I understand your concern. If I find that she's not doing that, then I will grant that motion.
Yes, sir.
Okay. Thank you, sir.
Love it.
Thank you. Mr. Lovett's case is 22 CF 1640. Mr. Lovett, have you ever been appointed a public defender in the past?
No, sir.
Okay. Do you wish for me to appoint a public defender?
Yes. I was trying to figure out, I got sentenced in the feds on the same charge.
Okay.
And I was trying to see, they were telling me I should get a dismissal or something.
Okay. You want an attorney to pursue that argument?
Yes, sir.
How long are you sentenced in prison for the federal case?
9 years.
Okay. I do appoint the public defender to represent you. Mr. Kleins is approaching out your left.
Maybe.
Yeah, so I'm kind of already half involved in this. So I'll look at your case and ask if there is some 14, but I suspect we'll file a motion to dismiss. All right. Your Honor, so for Mr. Lovett's case, we would ask the court for a one-cycle continuance. I was just advising Mr. Lovett. He sounds like he's in the same boat as I have Mr. McNabb. So when I file the motion for Mr. McNabb, I'll probably file one for Mr. Lovett also. I just need to talk with him at the jail before I do that. So I'd ask for a one-cycle continuance.
So, Mr. Lovett, what that means is that I'll see you no later than March 13th. But if Mr. Kleins files a motion before that date, he can set a hearing before then. Okay? Thank you, sir.
Collins,
And Allison, the folks that are in the gallery here,
they're here for Europe, and I was told to have Europe last citation. And Mr. Gavion is here with me, all right?
okay. Thank you.
Your Honor, this is Mr. Collins. We do have a meeting to resolve this case. There are some notations that are on this typed up plea form. Of course, that's the one time I actually typed a plea form. It's still got the handwriting on it. I've gone over the changes with Mr. Collins. He's just initialed before the changes were made. The agreement is that Mr. Collins is going to be entering a no contest plea on counts 1 through 5. So it's 1, 2, 3, 4, 5. The plea specifically on counts 2 and 3 is that Mr. Collins is going to be pleading no contest to an attempted crime on counts 2 and 3. Because of the nature of what we're dealing with in terms of numbers, on count 1, that's a second-degree felony, Mr. Collins is going to be sentenced to 72 months in the Department of Corrections with credit for all time served. Counts 2, I'm sorry, in exchange for that, Your Honor, counts 6, 7, and 8 would be null pros. Counts 2 and 3 are going to be, those are third-degree felonies. He's going to be serving 5 years of sex offender probation. On those counts, that will be consecutive to the sentence in count 1, but concurrent to each other. On counts 4 and 5, Mr. Collins is going to be sentenced to 4 years of sex offender probation consecutive to the counts 2 and 3. So the intent here really is 72 months in the department, followed by 9 years of sex offender probation. He'll pay $134.97 cost of the transportation payable to Okaloosa County Sheriffs. He will have no internet-capable devices, forfeit any seized devices. He will have GPS at $1 a day while on probation. There will be a sex offender designation. All statutory sex offender probation requirements will be imposed. He'll have no contact with minors. There is a curfew. It's on the plea form as a 7 to 7 curfew, but it's also noted that it can be adjusted for work purposes. There will be an adjudication of guilt. Mr. Collins would waive the PSI. May I approach?
Yes, sir. Is that the state's agreement?
Yes, Your Honor, it is.
Mr. Collins, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Sir, you raise your hand. Mr. Collins, are you currently under the influence of any drugs, alcohol, or medication?
No, sir.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those illnesses?
No, sir.
How long did you go to school?
Some knowledge.
Did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney? Did he answer all of your questions? Are you satisfied with his representation?
Very much so.
Did you sign the plea agreement?
Yes, sir.
Do you understand that if I accept your plea, that you're waiving the right to a trial by jury?
Yes, sir.
Do you believe it's in your best interest to enter the plea?
Yes, sir.
Are you entering the plea today freely and voluntarily?
Yes, sir.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anyone, including Mr. Kleins, said to you, if you don't enter this plea, you shall be sentenced to 3 years in prison or any other definite sentence?
No, sir.
Do you understand, have you had sufficient time to speak with Mr. Kleins about all the ramifications of being designated a sexual offender and the terms of probation with that designation?
Yes, sir.
Do you have any questions for the court or Mr. Kleins or the state?
We'll have to do a risk assessment and based on that.
Okay. So, did you give me the internet stuff? You have to do the risk assessment first. And if they say you don't have it,
Any questions?
Yes, sir.
Okay. Mr. Collins, I do accept your plea. I find that you're alert and intelligent, that there is a factual basis for entering the plea, for accepting the plea. You're adjudicated guilty on counts 1 through 5. Counts 6, 7, and 8 are dismissed. You're sentenced to 72 months with the Department of Corrections in count 1, with credit for all time served. Counts 2 and 3, you're sentenced to 5 years sex offender probation. Those will run concurrently with each other. Counts 4 and 5, you're sentenced to 4 years sex offender probation. And that's to run concurrently with each other, but consecutive to counts 2 and 3, so it'll be a total of 9 years of sex offender probation. You'll need to pay the $134.97 cost of transportation, have no internet access, you have to wear a GPS monitor at $1 a day, you will be designated as a sex offender, and you'll have all those requirements. You'll have no contact with any minors, and you'll have a curfew from 7 p.m. to 7 a.m., subject to probation can change that based upon your work schedule. Thank you. Usually I sneeze in 3, so in the future you can wait until the 3rd one. Thank you. What have I missed?
Point of clarification, Your Honor. We talked with the state. The no internet, that is at least until Mr. Collins does his risk assessment. If the risk assessment comes back and authorizes him to have internet, then he can. But it's no internet until the assessment is done, and then the assessment will control whether or not he has capability.
And he'll need to get the risk assessment and then petition the courts for internet access or contact with specific minors, whatever he's seeking to modify these terms, he'll have to petition the court for.
Okay, thank you.
I was just going to point out it's a little more involved than that. They got to have a risk assessment, safety plan has to be in place, and then the court has to wait.
Yes, sir.
Okay. If you get out of DOC and that's something that you look at, just call my office and let me know, okay? Typically, I would not be appointed on a case like that because it's so far down the road, but I certainly got no problem helping you figure out how to go back.
Mr. Collins? Yes, ma'am.
Sorry, could we also clarify the 7 to 7 curfew, that could be adjustable by probation without having to come back into the courtroom?
Absolutely, yes, ma'am. Mr. Collins, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, Mr. Collins. Good luck.
And may I have no action on any FTAs?
May I have the statute for the attempted?
Attempt is 77704.
Thank you.
I'm not sure if that is going on.
Thank you.
Your Honor, this is Darren Patton. We are going to have to be asking the court for a one-cycle continuance. I do believe that we are on the track here to get this case resolved. However, I believe that Mr. Patton may have another situation facing him down in Pinellas County that might complicate things. So I would ask the court for a one-cycle continuance. If we do get this resolved early, we will certainly advance it in the docket.
Okay. Mr. Patton, I'll see you back here no later than March 13th, okay? Thank you, sir. Thank you.
Yeah, this is Patrick Peoples. He is back before the court. We had attempted to enter a plea for Mr. Peoples last week. I did meet with him at the jail between last court date and this court date, and I can tell the court the hesitation with Mr. Peoples last week was caused almost solely by the length of time he's been in custody. He's been in for almost 18 years at this point, and he was, I believe, nervous, and he'll correct me if I say anything wrong here. I think he was just nervous of not being in custody, and that's such a long time. However, we have resolved this with the state. Mr. Peoples is going to be entering a plea on count 2 to an attempted sexual battery. In exchange for the plea on count 2, the state would null cross count 1. The agreed upon sentence would be that Mr. Peoples will be placed on 10 years of sex offender probation. That will be concurrent but not coterminous to any other length of probation. He's already on probation for the case that put him in DOC for 18 years. So it'll be concurrent but not coterminous. Mr. Peoples?
No contact with minors.
No contact with minors. There also will be no contact with minors. Mr. Peoples would be designated as a sexual predator. He would have to wear a GPS monitor as a condition of supervision. That would be at $1 a day to be attached prior to his release. He'd be assessed $615 in court costs, $150 in public defender fees. There would be an adjudication, as obviously previously been adjudicated. Yes, make sure I got everything there. That's it. May I go?
Yes, sir.
Mr. Peoples just asked the court to consider allowing him to do community service in lieu of any eligible court costs.
Okay. So the reason why I hesitate is Jimmy Rice. The Jimmy Rice Act. If Mr. Peoples, if he violates this probation with the designation as a sexual predator, then he could be subject to Jimmy Rice, correct?
And he could be, Your Honor.
I believe he's already subject to it.
But he's already an offender. And Your Honor, if I may put a few things on the record as a reason for downward departure.
Okay, hold on. Let me finish mine first. So he was previously adjudicated and determined to be a sexual predator.
He was previously adjudicated as a sexual offender. This case began as part...
But there's a difference between a sexual offender and a sexual predator.
Yes, Your Honor.
And this, if he enters this plea, it would be a sexual predator.
Yes, Your Honor.
Your Honor, I was advising Mr. Peoples about Jimmy Rice and kind of how that goes down. I'm also going to be giving him my card with my direct number on it. Please do not let this get out of your possession at the jail. But if you have any issues,
And this is a downward departure?
yes, Your Honor.
Yes, Your Honor.
Okay, yes, ma'am, to the state.
Just a few things that we'd like to put on the record. This case actually began its charge from the 1990s. This is an 05 offense report. It was part and parcel of a case that began in Bay County. So he has already served time in the Department of Corrections for that case. This case really only came back to us after he has served his time in the Department of Corrections on the Bay County case. We have been unable to locate one of the victims. That's why one of the counts has been dismissed in its entirety. The officer in this particular case is deceased. And given the length of time that has been since, of course, the offense in the 90s and the 05 report, and the status of the witnesses and victims in this case, that's why the state is agreeing to a downward departure in this case.
Thank you, ma'am. Mr. Peoples, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You can put your hand down. Mr. Peoples, are you currently under the influence of any drugs, alcohol, or medication?
No, sir, I'm not.
Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
Yes, I am.
Okay, tell me about that.
They treat me for depression. They label me as bipolar also.
Okay. Are you provided medications for
Yes,
that?
Yes, sir.
Are you currently taking them?
Yes, sir, I am.
Okay. What are those medications?
Zoloft.
Okay. Do you think you have a clear mind? Do you understand what the plea agreement states?
Yes, sir, I do.
Have you read the plea agreement?
Yes, sir, I did.
Do you understand it?
Yes, sir, I did.
Did you discuss it with your attorney?
Yes, sir, I did.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, I am.
Did you sign the plea agreement?
Yes, I did.
How far did you go in school?
Some college.
Good. Do you understand that if I accept your plea that you're waiving your right to a trial by jury?
Yes, sir.
Do you believe it's in your best interest to enter the plea?
Yes, sir.
Are you entering the plea today freely and voluntarily?
Yes, sir, I am.
Has anyone forced, threatened, or coerced you into entering the plea?
No, sir.
Has anyone promised you anything other than what Mr. Klein stated today on the record?
No, sir.
Has anyone, including Mr. Klein, stated to you that if you fail to enter this plea, you shall be sentenced to 5 years in prison or any other definite sentence?
No, sir, he hasn't.
So now to the Jimmy Rice. My background before I went on the bench was a civil attorney. And the first time I had a Jimmy Rice hearing, I looked at it and said, I have questions whether that's constitutional. Because what it says is that if the state prosecutes you as a sexual predator, and that's part of this plea agreement, that you'd be designated a sexual predator. If the state prosecutes you as a sexual predator and you go to a jury, it's a civil case, it's not a criminal case, but the jury can find that you still pose a threat to the community, and then the court can sentence you to an indefinite sentence to be held by the state of Florida until there's a determination by the court that you're no longer a threat, being a sexual predator. Do you understand?
Yes, I do.
Okay.
Just to pipe in real quick.
Please.
Just for Mr. Peoples' benefit, we do have an dedicated attorney in our principal office. We do know it's a civil issue. I'm guessing that this individual, Mr. Dunkerley, he's appointed to any JLA trials. So you wouldn't be without an attorney in that type of situation. But the last time I talked to Mr. Dunkerley, these types of trials are few and far between. So the judge is just really essentially saying, be aware that this could be an issue. I think probably every attorney that would look at the Jimmy Rice Act would at least initially say there's got to be some constitutional issues. It's passed all the tests though, so.
So, Mr. Peoples, the reason why I say that to you is I feel like my job was like when I was a mediator. I tried to get everything that I could tell you about your case, and then you decide if it's in your best interest to take the action.
Yes, sir.
So, knowing all of that, do you still wish to enter the plea?
Yes, sir, I do.
Mr. Peoples, I do accept your plea. I find that you're alert and intelligent, that your plea is freely and voluntarily entered. Are you satisfied with Mr. Klein's representation of you?
Yes, sir.
And that you're satisfied with your attorney? Yes, ma'am, probation.
Just wondering about an address, where he's going to be living.
So
Need to know for GPS.
that is his main concern, and it has been, and just simply because he's been in for so long. He's been working with some of the preachers, I guess, chaplains at the jail. He's going to be making contact with him. I've already advised Mr. Peoples that you need to report directly to probation and follow their instructions.
Well, he's assigned to the rescue office, so I mean, that is a very big dilemma. We have a homeless GPS sexual predator on the street, no addresses, he's going to be 1,000-foot rule and the school bus stop rule. This is very, very big.
Which is why I gave him my card and said, if there are any issues at all, please call me
There's an
directly.
issue right now, with all due respect, because we have to have an address in order to do GPS. We can't just have zero address. In order to enroll him, we must have an address.
So Mr. Peoples is going to have to give you an address before you can attach the GPS and before he's released from the Okaloosa County Jail.
Yes, sir, that's all part of the hookup. Did
Okay.
anybody send a brief where they accommodate the school bus stop in the festival? Did anyone reach out to Reed, the principal?
I have not, simply because Mr. Peoples has expressed his desire to remain with us.
I did call you yesterday, and they said I would have to have my probation and transfer release in here before they even take my name.
And we can't do that. We cannot transfer a homeless case, so that's it, sir. We're just putting this out there on the record, how much of a dilemma this is.
Understood.
So, for probation.
Understood.
It's obvious.
I've had clients, and not that I ever advise anybody to do it, but I have had homeless clients on community control.
Not sex predators.
And Ms. Shelton, am I correct that he's already has a probation officer assigned for the case he's getting out on from their county as well?
That is correct.
Okay.
That again, he could have only been assigned to that to Crestview because.
Okay, so that was for the offender status for the Bay County case.
Right.
Okay.
We'll be honest.
Okay. Mr. Peoples, do you understand that you're not going to be released from the jail until you can provide probation with an address? Okay.
And Your Honor, I hate to interrupt, but that address then would have to be, see if it even meets all the criteria that
Yes, ma'am. I understand. Mr. Peoples, you're adjudicated guilty. You're sentenced to 10-year sexual offender probation on count 2. Count 1 is dismissed. And that's concurrent with any other probation that you're on, but it's not coterminous. You'll have no contact with any children, with any minors. You're designated as a sexual predator. You need to wear a GPS monitor with a minimum amount per day. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost, $150 public defender's fee. You can perform any community service work and work off any allowable costs. Mr. Peoples, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
Yes, sir.
Thank you, Mr. Peoples.
You want to see Mr. Cadford?
Your Honor, if I can just jump around really quickly since I do have Mr. Cavion with me
Good.
today. Mr. Cavion is present 21 CF 104. And Your Honor, the state has an extended and amended offer to Mr. Cavion that he wholeheartedly would be accepting right this moment, but for the fact that he has a collateral immigration consequences that he needs to consider. He's been in contact trying to have a conversation with an immigration attorney just to kind of see what the impact could potentially be if he accepts that amended offer. And so if we could just leave this on for Thursday, so that he's expected to either talk to Mr. Marty Lester, and I'm sure the court remembers Mr. Lester, either this afternoon or tomorrow, and being able to kind of have a better, clear understanding. Certainly there's some major potential consequences for him if he goes forward and things go sideways, so he definitely, but he just needs to have that clearer picture. So if the court would just let us leave that on for Thursday in hopes that he can get some clear answers and accept the plea. I have made additional counter offers to the state. Mr. Gomez has indicated he's not able to accept any of those at this point. I have asked that he just go back to his supervision again. And given the unique situation that Mr. Cavion is in, because he does have a green card and he was going through the process of becoming a full-fledged citizen until this arrest, and that kind of halted everything. So he's in a very unique situation that I don't often encounter. So other than to tell him that even a withholding court cost could potentially impact him negatively for immigration, I can't really give him a clear answer. So I just asked the court, let us leave it on for Thursday. And then Mr. Gomez has also said he's willing to go back to supervision and ask again for me, so I appreciate that.
Okay, and if no agreement is reached on Thursday, then we're going to trial next week or a couple weeks after that. Correct?
That's what we're set for, Your Honor, at this point. Like I said, I do think we'll have an agreement. It's just...
Okay. I'll see you on Thursday at 9 o'clock.
Thank you, sir.
Thank you, sir.
And the other two cases that are on the docket, Mr. Bryan has a waiver on trial. This was set for your trial mainly based on representations that were made to me by the state attorney's office that at a minimum the firearm charge would be going away and the possession charge would be the only one we would be going forward on. That has since significantly changed. Given that, there are some additional motions that I need to file because law enforcement failed to preserve exculpatory evidence as to the firearm, so I obviously would be not effective in doing my job properly if I didn't file that motion. So based on this significant change in circumstances, need to request that the court allow me to continue it. I think the court knows this is not my MO, and so I am begging the courts.
Any objection from the state?
No, Judge.
It's continued one cycle.
Thank you, Your Honor.
Judge, and the offers at this point on Mr. Bryan's case do remain open. That would be dismissing that felon possession charge, or felon possession charge. So nothing changes as far as that end. It's just if we go to trial, it would be for both counts, not just the possession of a controlled substance.
Okay, Ms. Jakowitz, so you're aware of that now?
Yes.
Good. Okay. Thank you.
Yeah. And Your Honor, finally, I had called Eduardo Sanchez in 22 CF 2883 early this morning. The court asked that I reserve and call him this afternoon. This is the one that I believe, based on the minute sheet, did not appear for pre-trial. And then I was subsequently appointed.
You're coming back anyway, right? Do we have a docket for this afternoon?
No, Your Honor, I'm not coming back this afternoon.
Okay.
I don't have anything this afternoon if the court has a docket.
Do we have a docket this afternoon?
We have a docket this afternoon.
Okay. So locked in on this one. Okay, so what, I'm sorry, so who is that?
Eduardo Sanchez, 22 CF 2883.
Yes, ma'am. I don't see Mr. Sanchez. What is the state seat?
Capious judge.
Capious will be issued for Mr. Sanchez, and the first appearance judge will decide the bond.
And with that, Your Honor, that is all I have. If I may be excused, I'll see you on Thursday morning.
Sounds great. Thank you, ma'am.
There's a couple this afternoon, there are
Okay. And I'm sure I've done my homework. I just,
Sean Perkins.
what am I saying? Yes, at 2.
Your Honor, this is Mr. Perkins. We have reached an agreement with the state to resolve this. The agreement is that Mr. Perkins will be entering a plea of no contest as charged. The agreed upon disposition is that he will be sentenced to 36 months in the Department of Corrections. The special part about this plea, Your Honor, is that Mr. Perkins is going to affirmatively waive all of his prior credit before November 13th. So he's been getting credit toward this 36 months since November 13th. But anything prior to
2022?
2022, yes, Your Honor. Sorry. Anything prior to that is waived, but this 36-month sentence essentially started on 11/13/22. He will be assessed $615 in court costs and $150 in public defender fees, even though he's previously been adjudicated. May I start?
Yes, sir.
Can you repeat that date?
11/13/2022.
Mr. Perkins, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes.
Thank you, sir. You can put your hand down. Mr. Perkins, well, first off, are you under the influence of any drugs, alcohol, or medication? Have you ever been treated for any mental illness or emotional disturbance, or are you suffering from any of those at this time?
No, sir.
How far did you go in school?
I had 1 year of college.
Good. Did you read the plea agreement?
Yes, sir.
Do you understand?
Yes, sir.
Did you discuss it with your attorney?
I have.
Did he answer all of your questions?
Yes.
Are you satisfied with his representation?
Yes.
Did you sign the plea agreement?
Yes.
Do you understand that if I accept your plea, that you're waiving your right to, and this is a VOP?
No, this is a new law.
Okay. That you're waiving your right to a trial by jury?
Yes.
Do you believe it's in your best interest to enter the plea?
Yes.
Are you entering the plea today freely and voluntarily?
Yes.
Has anyone forced, threatened, or coerced you into entering the plea?
No.
Has anyone promised you anything other than what Mr. Klein stated today on the record?
No, I have not.
Has anyone, including Mr. Klein, stated to you that if you fail to enter this plea agreement, that you will be sentenced to 3 years in prison or any other definite prisons, any other sentence?
No.
You understand that you're waiving credit for all time served prior to November 13th of 2022.
Not good.
Any questions for me or Mr. Klein or the state?
None.
Okay. Mr. Perkins, I do accept your plea. You're adjudicated guilty. You're sentenced to 36 months with the Department of Corrections with all credit subsequent to November 13th, 2022. All monetary assessments mandated by statute or county ordinance are imposed. That's the court cost, $150 public defender's fee. Those outstanding amounts will go to a civil judgment. Mr. Perkins, you do have 30 days to appeal this judgment and sentence. If you wish to appeal, it must be in writing. If if you cannot afford an attorney to represent you for that appeal, one may be appointed for you. Do you understand your appellate rights?
I do.
Thank you, Mr. Perkins.
Did I get Your Honor back at the court?
Yes, sir.
Okay.
Thank you. Thank you.
Mr. McKee, just once, Your Honor, I very apologize. I was going to find out from Mr. Client when he intends on addressing the case that I have with him, because his client hasn't been transported, so.
Okay, let's ask Allison when.
He wasn't on our inmate list.
Right, that is the problem that I wanted to address sooner than later to find out what we need to do. That's all, Your Honor.
Okay, after this defendant?
Yes, thank you, Your Honor.
Thank you. Mr. Klein? Oh, I'm sorry. Mr. McKinney?
Yes.
Judge, this is Jose Herrero Cabrera. We had noticed this for a bond hearing at 1:30, and I know that he's got family coming at 1:30 to bring him back.
Yes, sir. Okay. To the case that you have? Who is the defendant?
Is it State of Florida versus Joseph Cousin?
And what's the case number?
Is 20 CF.
I have it, Your Honor. It's 20 CF 2701.
Yes.
Okay. So he's
So-
incarcerated and he wasn't transported?
So, if I may, since I brought it up, this case was set since last pretrial. Last pretrial it was continued one last time, and it was set directly for docket day, skipping pretrial last week from order of the court. And I was here to handle docket day because the case was set for plea or trial this cycle as one last time. I noticed that the case was indeed set on our docket today. However, the defendant was not transported from Okaloosa County Jail. And I'm not sure what Mr. Klein intends on doing right now because this should be going to trial. And I was gonna mention to the court that I'll be available the second week the state is ready.
Your Honor.
What is the defendant's last name?
Cousin.
Okay, good. Thank you.
Your Honor, the reason why the case was continued in December was we have been attempting to depose Dr. Benjamin Kretsch since last April. It was continued. Mr. Cousin stipulated that he would be fine with Dr. Kretsch appearing by Zoom, I believe at the trial also.
Yes, the judge already ordered that.
Right. I know.
Yes.
I know definitely the deposition and at the trial also. The situation is that it seems that both the state and the defense have the same contact information. I asked my investigator to reach out to talk to the state's investigator to find out if we have different contact information, and the investigators apparently have the same contact information. Additionally, just today, my investigator put a note in stack that Diana Torres, who we have been trying to reach since the state listed her as a witness in September, finally responded and sent my investigator 7 emails today. And so we've got one witness that I'm sure we could get a deposition done next week. Certainly sounds like Ms. Torres is now available. But this doctor is somebody that Mr. Cousin has wanted to depose since last spring. And we have done everything that we possibly can to find him. I even talked to my investigator and said we might have to hire an investigator in England to find this individual. So I talked to Ms. Leone out in the hall, and I tend to agree with what we had talked about, that an independent doctor could just come in and review the records, because the reality is this is an ER doctor that, in my experience, I've never deposed an ER doctor that remembers the details of anything that they've done. So I do believe that we could have an independent expert just review the records and possibly. But I know Mr. Cousin adamantly wants Dr. Kretsch or some doctor to be a witness in this case. And so I'll defer to the court how the court wants to handle that. That's the position of Mr. Cousin. I did meet with him at the jail in December, and was informed that, yes, that's exactly what he wants to take this deposition.
Yes, ma'am. You still want to go to trial?
Yes, Your Honor, because I just checked benchmark and all the notes. This case has been continued since 1/11/2022. That's only when Your Honor took the bench in Division 2, right? Not to mention what I'm saying. I'm not even counting the continuances from before. And the reason for the continuance for a whole year was the same exact reason of the deposition of this doctor. So we had the same issue last time. Defense correctly stated that also the state has made all possible efforts to get a hold of this doctor, but he's in England and he's not under our jurisdiction for subpoena purposes, obviously.
Okay, let me stop you once. Because Mr. Cousins isn't present,
Yeah.
what if we just continue today's hearings until Thursday with the understanding that at this point the court is planning to go to trial?
I can advise him of that. I can almost guarantee there's going to be an objection to that, given the steps we have taken. We have not just waited until the last second and tried to find this individual. We issued, I'm doing this by memory, it's either 3 or 4 subpoenas last year.
It would probably, your argument would be best served by doing a written
Certainly.
motion for continuance.
Certainly.
And if you can get that to me before Thursday, I'll do my homework.
I'll either get it, I keep thinking today's Monday.
Yes, sir.
I'll either do it this afternoon or first thing in the morning.
So Mr. Cousins' case 20 CF 2701 is scheduled for Thursday at 9 o'clock.
Okay.
Thank
and,
you.
And just the reason why he hasn't been transported, and it's been this way since he's ever been on a docket. For whatever reason, he is never listed as an inmate. And he's been in custody the entire time.
Allison, can you make sure that he's transported Thursday?
Booking? Yeah, yes, I'll make sure he's transported.
Thank you, ma'am.
That's just the holdup. It's just,
Yes,
I don't know why.
They just one little thing, Your Honor, that I need to mention. Just because you said the court intends on moving on with trial, based on the statements the defense made about the possibility of them listing their own doctor expert, so then I would need the chance to speak with their expert should they decide to go that route, which my argument was that he should have thought about it months ago to go this route, which, as I suggested.
I will rule on whatever motion is brought before me.
Thank you.
Allison, will you approach your mom?
I'm writing. Sorry, I'm writing a note. Your Honor, may I approach?
Yes, ma'am.
May I be excused, Your Honor? Thank you.
Okay, it's 12:30. I've got to let everybody take a lunch break. The first case we'll take when we come back is URAP. So just be mindful of that also to the media, because there are minor victims. You won't be able to record